Good morning and thanks for joining us. I'm Lauren Baker. Today is day 6 and week 2 in the trial of former Grand Rapids police officer Christopher Schurr. He's charged with second-degree murder in the killing of Patrick Lyoya. We have crews live across downtown Grand Rapids, both inside and outside the courthouse, ready to bring you updates as they happen. 13 on your side's Kyle Lichter and Riley Mack are inside the courthouse viewing the trial live and updating our live blog on 13 on your side. We also want to bring your attention to something that's happened this whole entire trial. We are delivering you the live stream of this trial on a court-mandated 30-minute delay. On 13 on your side, they were instructed by the judge to stream the trial on this delay so that any sensitive information that is not supposed to be broadcasted, like personal details, can be redacted before it is put on air. There are no other major modifications to how we are delivering you this trial, and we will remind you of this delay throughout the day. And as we wait for court, we're expecting for court to start at 9 this morning. Let's recap all the witnesses who have testified throughout last week. The prosecution called 2 friends of Patrick Lyoya, the last men to see him alive, David Bakuru and Ami Turumashe. 2 witnesses of the shooting, Wayne Butler and Fred Hunter, a GRPD crime scene technician, Jessica Brody, 2 Michigan State Police investigators, Zachary Batchelor and Aaron Tubergen, Kent County Chief Medical Examiner Stephen Cole, and an employee from Axon, the man who investigated the taser used by Schurr, Brian Childs, and finally 2 experts in the use of force and practices, Seth Stoughton and Nicholas Bloomfield. And finally, let's break down the defense witnesses. They started with a forensic video analyst, Robert McFarland, who testified on both Wednesday and Thursday, 3 police officers who worked on April 4th, Timothy Johnson, Sam Mott, Nicholas Kaladi, 3 GRPD police captains, all experts in GRPD policy, David Siver, Chad McCursey, and Jason Gady, an expert in exertion and exhaustion, Lon Bartel, a biomedical scientist and expert on taser effects on the person, Mark William Kroll, 2 experts in use of force, David Blake and Louis Von Kleem, and Christopher Schurr himself. We begin with Schurr's testimony. While Schurr was on the stand, he made a definitive statement as to what he did to stop the struggle between him and Lyoya and why he did it.
What have you been trained going all the way back to the MCOLS Academy as far as action versus reaction? What have you been trained?
That action beats reaction.
And what does that mean here in that scenario for you?
If I had waited for him to point it at me, it would have been too late.
And what were you fearful of?
That he was going to use it on me and I was going to die.
Now, and you were in a proximity to each other that he could do that to you?
Yes.
With how you've been trained about that device?
Yes.
Under your training, Chris, are you required to wait to be seriously injured or killed before you can resort to deadly force?
No.
So what did you do next?
I shot him.
Why?
I believe that if I hadn't done it at that time, I wasn't going to go home.
And Schurr had a lot to cover during his testimony and answer questions from the defense about GRPD's use of deadly force policy. Take a listen.
What level of force is firearm deployment upon a human?
Deadly force.
And in GRPD, do they take you through scenarios and situations that police might encounter as is exhibited on the video there?
They do.
The same scenarios as LCC, or do they go through quite a few more?
Definitely a lot more. LCC, you're more or less laying the groundwork and probably more book work and not as many scenarios. I felt as though Grand Rapids, we did more scenarios.
How many, roughly?
Probably thousands.
We saw just a sampling on the video of some of those scenarios.
Yes.
Now, as you're instructed on those scenarios, are you trained that there's only one way to effectively perform a task?
No.
What are they showing you there?
Essentially, there's a parameter, if you will, to handle it. There's definitely preferred ways, but there's definitely no person is the same. So the way I handle something is going to be different than what someone else handles something.
Now, does the GRPD Academy, similar to MCOs, do they try to expose you to some of the limitations that an officer may expose out in real life?
Yes.
Do they discuss topics like human reaction time?
Yes.
We also heard Schurr explain some of the videos we have seen throughout the trial, showing him being tased as himself as well as practicing with one. Take a listen.
Taser, taser, taser.
Okay.
That feel
Terrible.
What did it feel like?
Just essentially your muscles contract involuntary to their max capacity, and it's extremely excruciating pain.
Now, can you compare it to anything else that you'd ever experienced?
No.
Have you ever felt like anything like that before in your life?
No.
Now, after having felt the effects of the taser, would you volunteer to do it again?
No.
But prior to being tased there, did the master taser instructor give you some instructions on what was going to happen?
Yes.
What did they tell you?
They did a couple different deployments and varying spread, and he let me know how he was going to deploy it on me
Okay.
and
That-
where.
I'm sorry, where?
Yeah.
And does that help at all with any angst that you may have?
Probably alleviated some.
Now, when you were tased there, did you feel like you had much control over your body?
No.
And we've heard this term, I think, sometimes, taking the ride. Is that what they refer to it as, is when you're under the effects of the taser?
Yes.
How long does that ride last?
5 seconds.
Do you feel during that 5 seconds that you have the ability to defend yourself?
No.
What are you trained that can mean for a police officer in the field if someone fights them for their taser and uses it on them?
They would get access to our firearm.
Now, in police training, do you discuss topics like that? Officers getting disarmed of their weapons?
Yes.
Generally, what are you trained to presume if a subject forcefully disarms an officer of their weapon?
They would use it on us.
And Schurr continued his testimony, recounting details from his initial traffic stop and why he began a foot pursuit.
So you asked the driver for their driver's license, and what was his response?
He patted one of his pockets, I believe, initially when I asked for it, and then wanted to say that he said it was in the car, and I told him to get it.
Okay. Now, what did you do during this? What did you do at this point?
Well, I told him to get the license,
Mhm.
at which point he asked the front seat passenger for the license, and I just kind of take a step back and observe that the front seat passenger appears as though he opens the glove box and shuts it without providing any type of license to the driver.
Based on your 7 years of police experience, what are you sensing at this point?
At that point, I'm sensing he doesn't have a license.
Okay. So what happens next?
The driver shuts the door and begins to walk away from me.
And when can a driver just walk away from a police officer in this situation?
No.
Based on your experience and the circumstances that had transpired thus far, what are you feeling at this point?
Well, your stress level definitely goes up. You're going to end up going hands-on with the person. So it's a pretty stressful situation. It starts to raise your heart rate a little bit, if you will.
So what do you do next?
I grab onto him, tell him to put his hands on his head.
Why?
I just wanted to place him under arrest.
Okay. Had he committed violations that were arrestable offenses?
Yes.
What happens when you place hands on him?
He spins towards me and shoves me away.
Now, in your experience, when you go to place individuals under arrest, do they always want to be arrested?
I would say typically people don't want to be arrested.
But is one of your essential job functions, going all the way back to the MCOLS Academy, that you may need to effectuate arrest by using some level of force?
Yes.
Is that what you were attempting to do here?
Yes.
I believe you mentioned that the driver pushed you. Is that right?
Yes.
Was there anything else during this initial skirmish that you took as any types of aggression?
His fists were clenched.
And what does that mean if someone's fists are balled up to you?
Could lead to a physical assault on me.
So at this point, did this turn into somewhat of a tussle already initially?
It did, yes.
Under Michigan law, is it a violation, a felony violation to assault and resist a police officer?
It is.
So now what happens?
He proceeds to run away from me.
Does he get very far from you?
No, not really.
So what do you initially do?
Initially, I got on the radio just to let dispatch know that I had someone running to elicit a emergency response.
What does an emergency response mean?
Essentially, people will start driving with lights and sirens activated and exceeding the speed limit, in hopes to get people there quickly.
In your, maybe it was 5 years or so working in that area, when you send out a message for an emergency response, what is your normal expectation of having other officers show up on scene?
Well, I think one of the big things is that area is pretty well confined, and it's not like we're working in the city, so we have officers in a small area, if you will. Typically, when you say that over the air, you can hear the sirens just saying something like that on the radio, and I don't recall hearing them at that time. But also, I mean, cars typically get there within a minute or two.
Okay. Now, was the driver, as he started trotting away, was he moving very fast?
No.
On April 4, were you in overall good physical condition?
Yes.
And going back all the way to the MCOLS Academy, are you trained that you may need to get into foot chases?
Yes.
And are you trained that you need to often run into very volatile and unknown situations?
Yes.
Based on your experience working in the service area of Grand Rapids, why do individuals often run from police?
My experience has been that when people run, it's typically for some type of felony offense associated with what they're doing.
So, does any foot chase then, is there always some type of risk or perhaps danger to an officer in a foot chase?
Yes.
Is there a policy advising officers that they cannot foot chase?
No.
And during the struggle between the two, you can actually hear throughout the video that Schurr's taser went off twice. He was asked about the second deployment during his testimony. Take a listen.
Let go of the taser! Let go of the taser!
Please turn the light back on. Does it sound pretty chaotic right there?
Yeah.
And can you hear your breathing?
Yes.
Has it improved at all?
No.
And we've heard this talk in this time frame about a second cartridge. At some point in the struggle, did you ever notice that the taser deployed a second time?
No.
Does it sound like you're panting for air in that moment?
Yes.
And as you watch the videos now, the cell cam video now, are there other things going around you as well that you don't remember?
Yes.
And do you remember what people were saying around you at this moment?
No.
But after the fact now, you've seen this video many times, correct?
That's correct.
And have you heard this assertion that the taser was deployed a second time?
Yes.
But Chris, as you watch this video, okay, the cell cam video of the passenger, from the moment that we can now see the taser was deployed, do you fight, after that, do you fight any less effort into trying to get the taser back after that?
No.
Why is that?
I'm afraid he's going to use it on me.
And after this, Kent County Prosecutor Chris Becker began his cross-examination, confronting Schurr with Schurr's own report on the incident, which had contradictions to his testimony.
Okay, I think we left off. You were aware of the first taser deployment.
Yes.
Now you say you're aware he was holding his thumb. You saw the red. You were able to see the red on the taser when he was holding it underneath him.
Yes.
Even at that late stage, you were aware the passenger was outside the car yelling at him.
From the video.
From the video?
Correct. At that point in time, I was just focused on.
Okay, we're gonna go back to your written statement.
Yeah.
This is, well, you said
No,
from
no,
the
no.
video.
I did. Yes. If I can explain.
So yours.
I used the video to write the statement. Is what I'm saying.
So then what you wrote isn't exactly accurate. So you're basing some of the stuff you wrote on after watching the video, and you didn't really remember that, is what you're saying now?
I would say I was more focused on.
Because you're clearly right, you heard the passenger in your statement, but now you're saying you.
Yeah. No. I know you came out earlier. I think what you're discussing is later.
But then you're aware you couldn't hear the sirens coming to help even at that late stage.
No.
You're aware of that, for sure.
I couldn't hear sirens.
And even at the time, when you took time to fire that fatal shot, you were aware of the background. I took a look to make sure the background was clear.
I wrote it like a police report. Yeah.
But, I mean, wrote like a police report, but
Yeah. Going in
That's
that
what you wrote.
direction. Yeah. To imply that. Yeah.
so one of the things you can't train, you're not supposed to shoot if there's people around, you may hit somebody else. So you.
Correct. Yep.
Before you had time, you were focused, you knew that you could fire that shot because there's nobody there because you're basically looking at the ground, right?
It was going to be in a safe direction. Yeah.
At no point in time was Patrick ever on top of you.
No.
At no point in time, once again, he never said he was gonna kill you, right?
No.
Never said he was gonna hit you.
No.
Never said he was gonna kick your butt or do anything bad to you.
Not that I recall. No.
This entire incident, he was trying to get away from you.
Up until the end,
Up until, well, when you were on top of him, right?
I was on top of him.
Okay.
Yeah.
And he was trying to push himself up,
Yes.
and you thought he was gonna turn the taser on.
That's what I believed. Yes.
That's what you believed.
Yes.
But even the taser's not gonna kill you, right?
My impression is that it can cause death or serious bodily injury.
Okay. It's gonna cause death. You were tased, right?
Yes.
You're still here talking to us.
Yes.
You watch people in the recruit class get tased. They all survived.
They did.
In fact, nobody even got hurt, right? You didn't get hurt.
I didn't.
They didn't get hurt.
No.
So it's one of those things, it's always possible, but in your experience, you've never known anybody to be killed by a taser.
I don't have personal experience with someone getting
Nope.
killed by a taser.
Do you have any personal experience that you've been working for Grand Rapids Police for 7 years?
Mhm.
Any time where a police officer was seriously injured by a taser?
Not that I'm aware of.
No police officers in Grand Rapids Police were ever killed by a taser.
Not that I'm aware of.
once again, though, in your written statement, you didn't say you were afraid of getting shot by the taser. Didn't you tell in your written statement that you were afraid you were gonna get tased and then he was gonna go after your gun?
I would say I don't remember what it's in the written statement, but
You can take a look
Yeah.
at it.
so what is your question
The
exactly?
question was, is that your feeling, when you wrote this, you didn't say you thought the taser was gonna kill you, you thought you were gonna be incapacitated and then he was gonna grab your gun, right?
I think in the written statement, I think I said that it can cause serious bodily injury or death, just the taser, the use of it by itself, but the other part of it is, yeah, it would gain him access to my firearm.
That was your main concern, he was gonna access your firearm, right?
I would say both
Okay.
are my concern. I don't know, in that situation, I don't know where it's gonna get deployed. If it's deployed in a sensitive area, yeah,
At
it
no
could
point in
cause,
time did he ever go for your gun, did he?
no,
He never put his hand on your gun,
not that I recall,
he never touched your gun.
not that I recall.
Not that you recall, it seems like you would have, you watched the video,
Yeah,
you did a written statement.
yeah, no, I'm not, yeah, I'm not saying.
That never happened. So the only reason he did it is because he grabbed your taser.
No,
He had
because
control of your taser,
I shot him because I believed he was gonna use it on me,
because he had your taser.
because I
That's the
was
only thing you did.
afraid that he was gonna use it on
But
me.
that's the only thing he did, was he had possession of it. He never pointed at you?
He started to turn up towards me, and I felt if I didn't respond at that time, I wouldn't be here.
Sure, and he's not here, is he?
No, he's not.
I have nothing further, Your Honor.
And the jury had a lot of questions for Schurr while he was on the stand. Take a listen to those questions and his answers.
First, is the safety on the taser an on-off switch, or does it need to be held in the on position?
Good question. It's called a safety switch. It's an on-off. It's like a light switch. So it was on. I switched it on. It actually is some tension. I don't know the amount of weight to turn it on or off, but once it's on, it's on. It takes actual decent amount of physical pressure to shut it off.
And next, does writing a statement or a police report require you to write in the moment of the incident or for accuracy of what happened?
I think I get what.
Was right in the moment.
Yeah, I would. All right, if I answer that, I think I know what they're. If I understand the question correctly, I feel like there's a. I guess what I've been trained to do, there's kind of a difference in some part of it you're using the video, and then parts they have you just kind of go more or less off your memory for different various portions.
And the next question, in the beginning of the video, when the subject assaulted you prior to running away, at that time, is it okay within GRPD policy to use the taser prior to the tackle or in place of the tackle?
So that's kind of a loaded. To answer that, the strike could potentially justify under GRPD policy the use of the taser. However, using it on a subject that's running away, causing them to lock up and fall, especially around concrete vehicles, they hit their head, they could die using it or applying it in that manner, if that answers that question. So typically, we're not trained to use it on someone who's running.
Well, the question asked about prior to running away, so is your
Oh, prior-
response that
well-
you were on concrete, so.
Well, I think he starts to run at that point. So,
Well, the
I
question
think-
is prior, in the beginning, when the subject assaulted you prior to running away, at that time, is it okay?
oh, prior to running,
use the
actually
taser?
physically running, I would say yes. But the amount of time it takes me to get my radio out, he's already running at that point. So then we're in that same situation that I'm was discussing, if that makes sense. The actual, I think it would be petty to use a deploy taser for what he did. That, for me, that's my opinion, based on just that information.
Okay, next, did you feel at any time prior to you presenting and deploying your taser that the subject was trying to grab or obtain the taser or any other weapons on your belt?
Was the question prior to?
Did you feel at any time prior to you presenting and deploying your taser, the subject was trying to grab or obtain the taser or any other weapons on your belt?
Prior to deploying the taser, I didn't feel as though he was trying to grab any weapons.
Next, do you recall being able to smell alcohol on Mr. Leolia during your first interactions?
No.
Next, when you say you saw the taser being held as a handgun by Leolia, did you prioritize attempting to press on the safety or to turn the safety off or to remove the taser?
The entire goal was to get the taser back. I couldn't get it back. The only thing I could potentially get my fingertips on was the safety at that point.
I know I asked about alcohol during your first interaction, but at any point did you notice he was under the influence?
I didn't smell it or notice it in those moments. Based on his actions, I would believe it, but I wouldn't just say because of him not responding to some of the tactics automatically means that he was under the influence. So I guess the answer is no.
Next, when you write a statement or police report, what is the process?
Depends on the report. If it's a more involved report, we'll review video as much as we can, and then type it, and it might go back and forth.
Do you require running through new scenarios each time a new model taser is introduced?
You definitely do different you do scenarios when you get a new taser, for sure. However, when it might be the same scenario, when we switched to the new model, the bigger thing was the effectiveness at close range because of the design of the cartridges itself. So, and we didn't have to worry, the way the cartridges were designed were better for close, we didn't have to, I don't want to get into the actual design because I can't remember the original taser. I hardly remember the one that I used in this, but the big thing was it was more effective at close range and to train to use it in that manner.
Next is, why do you shoot Mr. Leolia in the head?
I wouldn't say that I was necessarily aiming per se. I only had essentially a viewpoint of his upper back and head area. I deployed my handgun and fired it in that direction. It ended up hitting and striking his head.
Mr. Dodge, did you have any follow-up questions from any of those?
I do not, Your Honor.
Mr. Becker, how about you?
I'm done, Your Honor.
I don't see any other hands. Oh, there's one hand raised on the jury. Next question is, when is running a license plate allowed? Is driving too slow reason enough?
to my knowledge, we can just drive around and run license plates whenever we want. And to answer just driving too slow, I guess potentially driving too slow depending on the speed limit you're in. And I guess if you are exceedingly below the speed limit, yes, that is a traffic violation. That wasn't necessarily what I was stopping him for that day.
And joining me now is Emily Scarlett. Emily, you've been watching this case all week long. We're into week 2 now. What are kind of your thoughts with the start of the new week?
Well, I know initially when we were first starting preparing for our coverage of this trial, initially as we were preparing with the courts and representatives for the court, we were told that this potentially could go 1 week. And so we have been sort of keeping an eye out for whether things were wrapping up, and especially seeing Friday morning, first thing with court starting, Schurr taking the stand. I think then again we thought, okay, possibly this is another sign things are wrapping up and they're getting ready to bring things to a close as we end this first week. But then sure enough, Schurr gets off the stand and they call more witnesses. So again, we're still sort of left with this question: how many more witnesses will we see for the defense, and just how much longer will this go?
Yeah, I think you bring up a good point. Is that a lot of us thought that things might be close to the end, and then we saw more witnesses. We're going to bring in Andrew Rodenhouse. Andrew, we talked to you last week before more witnesses were called. Kind of right off the back, what is your reaction going into week 2?
What's that?
I'm sorry, I don't know if you could hear me, but I was asking kind of your reaction going into week 2 of this trial. Looks like we're having some technical difficulties,
Okay.
but I think it'll be interesting to see what happens.
I can hear you,
know?
yes. Can you hear me okay?
There he is. I
Yeah.
think we got him now.
I feel like I got something going on in the background.
Okay, but are we coming through clearly? Can you hear us?
Yes, I can hear you just fine.
Okay, well, we can hear you clearly, and now you're up on our screen so we can see you as well. So we just wanted to quickly get your opinion on going into week 2. What are you expecting? What are you hoping may happen? You know, what are your thoughts?
Well, I thought we had an interesting day Friday to close out the week with the experts from the defense. I know Mr. Becker is still in cross-examination of the, I think his name is Von Willis, the expert for the defense that was testifying about kind of the culmination of all the defense experts all together. And I found his cross-examination interesting. He was pretty aggressive. He was aggressive with both of the experts that they had called on Friday. The first one, he was challenging his, basically his education, which is, an attack on an expert's education is kind of like, similar to saying that your conclusions are wrong. And then on this latest one, he seemed to be challenging him that this website you run that posts these articles from law enforcement for the law enforcement community, that somehow some of the other authors, like their viewpoints, he's questioning whether or not that shapes his opinion. I thought that was maybe a little unfair. I mean, it's a media publication, and so maybe not necessarily the owner of the website or the, let's say, for example, like the New York Times, they publish an opinion piece. I think most people understand that that's not the official position of the New York Times. That's just that author's opinion. And so I think that Mr. Willis was trying to make that clear. Like, look, this is a perspective, and so it's a spectrum. And I'm expecting I think there's going to be fireworks this morning with Mr. Becker's cross-examination of Mr. Willis, and so I'm kind of looking forward to listening to it.
Well, I know I was so curious, Andrew, by the fact that we saw Christopher Schurr take the stand, and I know I certainly thought, okay, this means the end. I thought it was unusual to see more witnesses come on after Christopher Schurr. What does that mean about that approach? I thought, well, maybe Schurr wasn't sure, and so while he was feeling confident that day, they wanted to just go at it then. Of course, I have no idea. Is there possibly a strategy to that?
Well, I think that there was, and it was because somebody had to lay the foundation for, this expert to say that, hey, when somebody's exhausted, they lose the ability to have all their senses about them. So like their hearing, they might not hear stuff. They might not see things. I know from my experience in playing sports that the more I exert, the more tunnel vision I get, and so that's a common biological response. And so I think that what their strategy was is to have Mr. Schurr testify and then bring in experts to backfill his credibility. And I found it interesting that yet Mr. Becker has yet to really attack those conclusions. And maybe he will. Maybe he's got some rebuttal witnesses that will attack those conclusions.
And speaking of the rebuttal, that most likely will happen, for people who don't know how trial works or what could happen in a case like this, can you talk about that rebuttal? I think some people think, oh, once the defense closes, that will start closing arguments right away. But actually, it sounds like Becker has a chance to kind of go back at what's already been said.
Yeah, so let's break that down a little bit. So what I anticipate is that when the defense is done with their case in chief, then the prosecution has the opportunity to rebut anything that the defense brought up that was outside and not rebuttal to the prosecution's case. And so if they have a rebuttal case, it's not a chance for Mr. Becker or the prosecutor in general to introduce new evidence. The only thing they can do is rebut evidence that has already been admitted by the defense. And then typically those are in normal trials. There's and I say normal versus abnormal. This is an abnormal trial. So I want the public to understand that some aspects are normal about this trial, other aspects are not normal. It's not normal in most trials to have this much defense testimony. I mean, if you can think back, Mr. Becker only presented about a day and a half. The rest of this time has been all defense. So that's kind of unusual, but typically the rebuttal from the prosecution is fairly short, if at all. Oftentimes prosecutors will move directly into closing arguments and waive any rebuttal. I don't expect that to happen this time. I expect there to be some type of rebuttal by the people, but I don't think it will be a whole lot. But we've all been surprised throughout this whole process. But then once the rebuttal is done, I assume the parties have already finalized the final jury instructions with the judge, and if they haven't, they'll do that soon. And then what I expect is closing arguments. I don't know. Some judges will limit closing arguments. They're allowed to limit closing arguments to a time limit to keep it efficient. But some judges will let lawyers go as long as they need to. And so we'll see what Judge Mims decides to do on that. And then after closing arguments, then the jury will get read all the instructions for all the instructions they're going to get, and will be given a copy of those instructions to take in with them into the jury room for deliberations.
I was hoping
go ahead.
I'm sorry, I didn't mean to cut you off. I was hoping you could elaborate on that a little bit more. What will that rebuttal look like? You said Becker or the prosecution cannot present new information, but does that mean calling people back to the stand, possibly more people being questioned, and that extending the time as well? What does that rebuttal look like? Are they just statements, or we're hearing from more witnesses?
It could be bringing back witnesses that have already testified. It could be bringing in a new witness to rebut a conclusion. So, for example, let's say that the defense said that, well, Mr. Schurz didn't hear that second taser go off and didn't hear whether or not he was getting sirens in response to his call out for additional officers, and that was part of his decision-making process. For example, the people might call in an expert to say that that's not what happens on a biological response to this much exertion. So they would be allowed to bring in an expert to say that that's not true. I don't know if they have anybody like that or not. I would have expected that more in a case in chief, but I'm not the lawyer making those decisions. But that's how rebuttal is limited to whatever the defense presented that was not presented by the prosecution already.
And just for those who are watching, Judge Mims has called court into session at 9:07. Again, we're on that 30-minute delay, so you'll see that, and Von Kleem has taken the stand again. But I wanted to ask you, Andrew, in regards to having Schurr kind of in the middle of all the witnesses, when a lot of people, when we saw that happen, a lot of reaction we saw is, wouldn't you want to end with Schurr? Wouldn't you want to have like a lasting impact, especially going into the weekend? You kind of want that like final punch. Can you maybe talk about decisions to put a specific witness in certain areas, and that it's not really a black and white situation when it comes to where you put maybe a key testimony in your lineup?
Yeah. Let me talk about that. So there's So first of all, we're not sitting at the defense table, so we have no idea what their strategy is or why they're doing anything in particular. It could be that their experts hadn't arrived in town yet, and they have to fill that space. It's their time, and so it could be that's possible. And I'm just speculating, but it's possible that Mr. Schurr went at that exact moment in time is because that was the only witness that they had available for that particular moment. So that could be the reason, or it could be that they wanted to have Mr. Schurr testify and then have these experts backfill his credibility. That is also a plausible explanation. So I wouldn't read much into why they did it at this particular time. I don't think it's all that important, the reason why. I think what was important was what all the people testified to.
It's interesting that you mentioned Becker being aggressive in some of his cross-examination. I was just looking through some of the comments on our YouTube video of the trial being streamed, and I saw some of that criticism for Chris Becker as well, that he was being really aggressive, that he was being a wordsmith, tripping Christopher Schurr up on some of his responses. Do you think that that's something that could have an impact on the jury, and how might that affect the case if some people are perceiving him in that way?
It could, and if a juror sitting there thinks that the prosecution is being too aggressive, or they're being manipulative, or they're trying to run a game, that can have a negative impact on the entire case for the prosecution. It cuts both ways too. If they think that Mr. Schurr is being evasive or not answering the questions, then that goes to his credibility. And so absolutely, those types of exchanges are something that lawyers, when they're trying cases, think about all the time. Like, how am I going to respond? How am I like to call it. So, for example, like, let's say you have a victim of a crime testifying. Well, oftentimes they're very sympathetic, and the prosecution will present them as sympathetic. And so, as a defense attorney, you can't always just jump in there and be real aggressive with a victim. Sometimes you have to do what I call a soft cross-examination, or a compassionate cross-examination, and where you're not trying to be offensive. What you're trying to do is just get to the truth. Maybe they've made a few other statements before, and you don't come at them real aggressive. Maybe you stay seated and sit down and talk to them so that you're more on their level, so you're not like towering over a witness, particularly if it's like a child witness. Then, I'm a big person. I'm, 6'4", and if I'm towering over a child victim, then the jury would absolutely hate that. And so that would really cut against my client if I was acting that way. And so the jurors do pick up on that stuff.
And I wanted to go back to the witnesses we saw after Schurr. They were not part of DRPD. You're starting to see the defense bringing people who are not from this area. Do you think that helps or hurt them? Because I know a lot of people, when Prosecutor Becker was bringing his witnesses, there was a lot of question of, well, these people are not from this area. And I almost think the defense kind of put an attack out there a little bit to say that, like, they're not even from our area. But now they're bringing people that are not from Grand Rapids. Does that help them or does that hurt them?
I don't really know. I mean, again, this is all questions that after this trial is over, if you have the opportunity to talk to some of the jurors, you could ask them that question. My personal thought is that if you're going to attack for being an outsider, then bring in outsiders, that maybe that's not the best look. But at the end of the day, the prosecution didn't call any of the local law enforcement officers who are part of the police policy in this area, specifically in Kent County and Grand Rapids. and the defense did. And I thought all those officers did an excellent job testifying that what Mr. Schurr did was what they considered reasonable. And so I thought that that was probably the most impactful of the whole trial, at least from my perspective.
Now, we talked about the fact that jurors have the opportunity to ask questions during the trial as proceedings move forward, and we've heard several questions from the jurors at this point. We talked to you before, Andrew, where you said that is not unique to the state of Michigan, though it may be unique to the country where courts are allowing jurors to ask questions in that manner. It's just so interesting to me, paying such close attention to this trial and hearing from the jurors mid-trial. It's hard not to speculate in terms of which way they're leaning just based off of their questions. I know some questions that were brought up with Schurr on the stand. Did Leoya grab for your taser before you presented the taser to potentially activate it? Did you smell alcohol on Leoya in your interactions? And when can you run plates? Just anytime, or because someone's driving so slow? So again, we're sort of hearing from jurors in ways that we maybe wouldn't before they're able to deliberate. It's hard not to sort of glean where they're headed.
Yeah, absolutely. And that's one of it's one of the pushbacks about allowing jurors to ask questions. And we don't know if it's the same juror that's asking the same questions, because when you're in court, you can see who's writing, writing questions on notepads, and after a while, you can figure out which individual jurors are asking, these types of questions. We don't have that information in front of us, but certainly the trial attorneys do, and after a while, you start to recognize, the unique writing styles, and so you can quickly figure out which jurors are asking which questions. And the problem is that then do you cater? Is everyone having that same thought, or are you going to try to cater evidence to that one particular juror? And that's where, when you get into the questions, I'm kind of torn both ways on it. I can see how it's a positive. I also can see how it's a negative, because once they get into the jury room, that's why you deliberate, and all the jurors can express their opinions to each other. And oftentimes people change their opinions from writing questions and maybe forming an opinion one way, but then they hear from the other jurors who maybe didn't ask any questions, and they get a different opinion, and sometimes they'll adopt those opinions. And so from a questioning standpoint, I think the big drawback is that we start reading too much into that, and it's not really all that important. And when we'll put on evidence that we shouldn't have, and then all of a sudden you're persuading people the wrong way. And so I think it cuts both ways. I think it's interesting, but I don't really have a hard opinion one way or the other on it.
This question might be jumping too ahead of ourselves, but last week when we spoke to you, Tanya, and Anastasia Marcoux, he mentioned that there's a possibility that the judge could throw in a voluntary manslaughter charge for jurors to decide on. I didn't get a chance to ask you on your opinion about that, but do you think that's a possibility, and how does that change how this case continues?
Well, I think it's highly likely that the judge will include that, because I think Mr. Becker might have charged it as a lesser included, and if he did, then I think the judge will keep it, because I think we've heard enough evidence to support the jury being able to consider that. And the way it would work is that they couldn't convict him of both. They would have to start with deliberating on the second-degree murder. They'll be given a jury verdict form, and it will clearly state on there, start with murder in the second degree. If you find him guilty of murder in the second degree, stop, you're done. If you find him not guilty of murder in the second degree, go to the second one, which is would be manslaughter, and then deliberate on whether or not he's guilty of manslaughter or not guilty of manslaughter, and then that's the end. So the jury could, because self-defense is a defense to both of them, but the jury would be given the opportunity to consider the lesser included of manslaughter.
Well, we're just about out of time, but I did want to ask you quickly in layman's terms, what is the difference between that second degree and manslaughter?
Okay, well, very quickly, I'm not going to give you that answer because it's not a quick answer. But I can tell you the difference between, in the penalty is is greatly different. So if you're convicted of murder in the second degree, the penalty is any period of years. The judge can sentence you to any period of years. I've had famously one client was sentenced to 100 to 200 years for second degree murder, but it's any period of years up to and including life. In Michigan, if you're sentenced to just a flat life, then you have to do a mandatory minimum of 25 years before you can be paroled. But if you're convicted of manslaughter, of any variety of manslaughter, it has a maximum penalty of 15 years. And usually the minimum penalties start around 2 to 5 years. The judges can sentence up to 10 years as a minimum for manslaughter. But then the maximum, meaning that they could never hold you incarcerated longer than 15 years, would be the maximum penalty. So the biggest difference is in the penalty phase. I think that's probably the best way to explain it for the lay people in the audience.
Yeah, no, that makes sense. Such an important distinction.
Yeah, thank you, Andrew, for coming. I know that for those who don't know, Andrew is an attorney. He has work today, so we're going to let him get to court. Thank you, Andrew. We really appreciate you coming in.
Thank you. You're welcome.
And I think that kind of shakes things up. You know, we have a lot of people thinking that Schurr could spend the rest of his life in prison, but if the jury does decide on a lesser charge, you know, that could change people's opinion on things.
And so interesting to hear Andrew talk us through that actual process, that first you will need to consider the larger charge, and if they end there with a guilty verdict, they won't go any further. But should they not reach a guilty verdict on that, then they possibly, because this has not been decided yet, but if that happens where the jury is also given this manslaughter option, they'll have to decide on that second degree charge first. If they don't come to that decision, possibly they would have that manslaughter option as well.
It's going to be interesting to see how the jury looks at this case. Obviously, they've gotten so much information to be able to decide what they, you know, believe or don't believe. But throwing in that second charge, you could have some people who right now are saying, you know what, he may be guilty of something, I just don't know what, and bringing in that manslaughter, not saying that that could happen for our viewers, but you know, that's something that I think a lot of people aren't thinking about, that could be a different charge that we can see come out of this.
How could that change their perspectives on making a decision here? But it is just so interesting and fascinating watching all of this, because it is just such a passionate argument. I mean, you've got people feeling so strongly on both sides. One side is like, for sure, he did something wrong here and should be penalized, where other people, I was, again, just reading the comments before I joined you here on the desk, Lauren, where other people are saying, you know, this never should have even gone to court. This is ridiculous that this man is being questioned or persecuted for doing his job, as some would say. So people, really strong opinions on both sides. And I'm not seeing a lot of people in the middle.
No, not really. I think a lot of people, because obviously situations like these hit people differently. You have families who are, you know, have police officers in their families, and that idea that a situation like this could happen, they could lose a loved one, scares them. But then you have other people who have very different experiences with officers, who feel very passionately about the way they do. So I think what's telling about this case is just how it has really grappled the community. Again, this happened 3 years ago, and it almost seems like people's emotions are still very raw when it comes to this case.
Yeah, and that's such an important part of this case as well, because the witnesses that are being called to the stand, especially those that are testifying to what happened that day, people's demeanors, what happened after this incident, what happened when this happened. And like you said, we're talking 3 years ago. Some of these memories just aren't that clear for everybody involved in this case now.
Yeah, and back to the stand today is Louis Von Kleem. He's a use of force expert from the defense's side. Before we see him again for cross-examination today, let's listen back into his explanation on how training becomes tactics in a situation like Schurr's.
What is understood in law enforcement training and tactics is tactics are discretionary. There's not a single tactical solution, there's just tactical options. And when an officer is facing a tactical scenario, they have to make their decisions based on risk, benefits, and trade-offs. And they're the ones that do it in real time based on some things just like their confidence level. Are they tired that day? Are they injured that day? The officer gets to decide, because there are so many variables, and I know this is true in Grand Rapids. They consider there are so many variables, they're not going to write a policy on foot pursuits because they need the individual officers in that moment to make those decisions. And so when you look at the types of things that officers consider in that risk, benefits, and trade-offs, You do look at, well, how tired am I? How far is my nearest backup? How, am I gonna chase, am I actually gonna catch the guy? Is he bigger, stronger, faster than me? What do I know about the area relative to crime? What time of day is it? There are so many variables that go into that quick decision that a lot of places don't have a specific policy. And here's what's really important. All of these considerations and the totality of the circumstances of every decision, right? You keep hearing that. Do I chase or not? Well, it depends on the totality of circumstances. Understand the totality of circumstances are things that we consider in a classroom setting and we talk about them, and then we go into a training room and we operationalize them, we implement them, we do it in training so that they become aware of them. Once you're out on the street, you're not doing a math problem where you're counting the number of people and looking at the time of day. You're looking at it very quickly and saying, I've seen this before, and you make a decision. That's the heuristic decision, a rule of thumb decision, right? So we don't ask, and the courts don't require this, for officers to engage in this sort of library scholar approach to the totality of circumstances in that moment. The totality of circumstances are things we incorporate in training and in lecture, and then we look at after the fact in the evaluation. But in the moment, we expect in a critical incident, this is also in Stoughton's books, I don't think he would disagree with this, that officers are expected to engage, are not expected to engage in slow, deliberate, rational decision-making during a critical incident. They're expected to engage in what we call fast and frugal, system one, fast heuristic decision-making. Why that works for cops is because all those totality of circumstances are things that we put in training. And so you heard their trainers say we try to develop realistic training so that when they're on the street, I think he said I don't think he said automatic, but it's conditioned, it's automatic. Because you do not have time to do that math problem in real time, in many cases. And I think you asked that question, we'll come back to it later, but there are times when you can do slow, deliberate, rational decision-making. I think one of the experts talked about that. And there are times where that's just unrealistic to expect of any human.
For those who follow us on social media, you may have seen that the defense has actually rested their case. Obviously, again, we're on that 30-minute delay, so you will see that in about 30 minutes. But again, the defense has now rested its case, and I'm hearing that Becker has started his rebuttal, bringing in one witness so far. But Emily, I mean, it seems like we get done talking with one expert, they kind of predict what's happening, and then it happens.
Yeah, we are now into this next phase with things wrapping up here, because we know with the prosecution's rebuttal, after that comes the closing arguments, and then presumably it goes to the jury for them to deliberate. So we are now reaching those final steps of this process. Still really not clear to know just how long these final steps will take.
Yeah, I think it shows just kind of the life that this case has taken. That's something that our experts have talked about a lot, is that this, like Andrew has said, there are some aspects that are very normal, some aspects that are not. I think a lot of people thought that this would only take a week. We're now into week 2. It could be a short week 2, but we're definitely into week 2, and who knows how long this case could go on.
Yeah, interesting, going back to the sound that we were just hearing from that witness. Again, going back to this phrase of the totality of circumstances. This has been something that we've heard throughout the trial, where essentially, I think even witnesses on both sides are having this argument to say, hey, I think he even referenced, it's not a math problem. It's not a certain formula where you are able to answer the questions that many of us have in this case. And that's what makes, I think, this conversation so complicated in what we're discussing. There's no black or white answer, or like he said, it's not a math problem where you can say, all right, well, with step 1, an officer can do this. Once step 2 happens, an officer can do that. Every situation is different, and that's what we've been hearing. It's the totality of the situation. It's not this simple formula that law enforcement can follow.
Definitely. I want to bring in our live blog. Riley Mack has been updating this for us as the day progresses, and she says the prosecution calls Sergeant Aaron Tubergen, sorry if I'm mispronouncing that, with the Michigan State Police to back to the stand. He's the investigator that was in charge of the case. The prosecution admits a statement Schurr gave after the shooting, and Tubergen says it was voluntarily given. Schurr's attorney, who is on the defense, oversaw Schurr writing the document. So again, looks like they're bringing in, I believe he was kind of earlier in the witnesses that we saw on that first day to talk about. He was the one who was in charge of this investigation. As you recall, when situations with police happen, the agency that the person is from cannot investigate. So Michigan State Police did jump in to investigate. So it's interesting to see that they brought back this person.
Well, and it will be interesting to see the direction that Becker or, you know, whoever is questioning this person with the prosecution, what direction will they be going in, and what is this final point? Of course, this is the rebuttal. So again, an opportunity to, Andrew just said, not bring in new witnesses, but maybe tie up some loose ends as the defense was making their case. I just wonder, what is this, you know, final point that the prosecution is wanting to make with this rebuttal? It'll be interesting to see what points are made here.
And an update that our producer just gave us is that that judge has confirmed that all evidence in this case has been presented, and now they're discussing kind of the parameters around closing arguments. So far, a very fast day on day 6 in week 2. We thought that maybe it might be the same as last week with multiple people, but looks like things are going pretty fast.
Yeah, things are moving right along. And, you know, Andrew also mentioned that Christopher Schurr had written this statement shortly after the incident, and that was something that would come up again in this case. We even saw that with him being on the stand, and especially during his cross-examination. Chris Becker was actually going through that statement that Christopher Schurr made shortly after the incident, almost word by word, to the point where the defense was objecting to just how much Chris Becker was going through that statement, saying, hey, are we gonna, you know, go through every question here? And Chris Becker said, yes, we are, because he was trying to show, he said, Christopher Schurr's state of mind at the time that statement was written, and contrast that to how he was now making his case on the stand today. So just interesting how that statement has come back into play here.
It shows how thorough both sides are trying to be. They're really trying to show their case, and every chance that they get, they're going to hit it as hard as they can. You can see that with what you just said, you know, bringing back kind of like a full circle of trying to really show the jury, this is our thought process and this is how we get back to this. Riley Mack just let us know in our live blog that a recess has been called at 9:29, which again, if you remember, court started at 9:07. I think this is the shortest session we've seen during this trial so far. Usually we take about an hour and a half, 2 hours before we hit our first recess, and roughly 20, 30 minutes.
Yeah, before we could even bring that delayed stream to the viewers, court is already in recess.
Yes. So it kind of shows maybe how fast and how maybe ready both sides are. They have presented all the information that they think that they needed to. The judge has said herself that all the evidence has been brought in. Therefore, soon the jury could start deliberating. I mean, obviously we have closing arguments, and closing arguments, like Andrew said, that could be limited. But I mean, if we're only hitting 9:30 Monday morning, she may say, oh, take all the time you need, and closing arguments can last half an hour to an hour each. So it'll be interesting to see what they decide to do.
Yeah, I mean, we're basically going to start to see them put a bow on the many arguments that we've heard over the last, 6 days now at this point. Of course, this trial started 1 week ago. And so we've heard several witnesses at this point. I can't remember now the exact number.
Yeah, it's been a lot.
It's been a lot of witnesses and a lot of information, Lauren. I said it earlier and I'll say it again. I do not envy the job that these jurors have, because it's just so much information that they're going to have to process. I mean, we talk about the time that closing arguments may take. How long will it take for the jury to deliberate?
Right, exactly. Now, a lot of people, again, it's so much information that we've gotten today, so much information that has happened in the last 30 years. We kind of want to walk you back how we got to this point. Take a look at the reporting from Callie Lichter. She kind of shows us a timeline of what led up to this trial. Take a listen.
8:11 a.m., April 4th, 2022.
1915.
A Grand Rapids police officer pulls over a tan Nissan Altima near the intersection of Griggs and Nelson Southeast on the city's southeast side.
Hey, stay in the car! Stay in the car!
Patrick Loyola, a 26-year-old refugee from the Congo, exits the vehicle, disregarding commands from 31-year-old Officer Christopher Schurr, a 7-year veteran of the force, to remain inside the car.
You have a driver's license. Do you speak English? No. Stop.
Almost immediately, a struggle begins that lasts nearly 3 minutes and ends when Officer Schurr shoots Loyola in the back of the head.
Drop taser!
That same day, the investigation is turned over to Michigan State Police, and city leaders gather to tell the public what has happened.
This is indeed a really difficult day for our city, and my prayers go out to everyone impacted by today's tragic incident.
A little more than a week later, on April 13th, dash cam, body cam, and cell phone video shot by the passenger in Leoya's car is released to the public.
Stop grabbing him like that. No, he good like for real. Yo, you hit him too.
But for many, it is not enough.
Our streets!
Frustrated, people take to the streets demanding their voices be heard. On April 22nd, nearly 3 weeks after his death, Patrick Loyola is laid to rest with family, community members, and civil rights leaders attending.
In Grand Rapids, we have to play our part now.
Fast forward to April 27th.
Let him speak and stop disrupting this meeting.
Commission meetings are packed with community members demanding the officer's name be released and that he be charged. After weeks of public pressure, Chief Eric Windstrom, just over a month into his new role as chief, publicly identifies Christopher Schurr as the officer involved in Patrick Loyola's death. Christopher Schurr is later charged with second-degree murder on June 9th and fired from the force 1 week later. In December, the Loyola family files an excessive force lawsuit against the city of Grand Rapids and the police department.
And we did get some clarification on that recess. That recess was just for the jury. So when we're able to show that live stream, people will be able to see that recess with the jury not in there, but the defense, prosecution, and judge just kind of discussing those closing arguments requirements.
So we should be able to bring that to you here very shortly. But again, we do know that the defense has rested, so we are beginning to see the final steps of this trial.
And I think what's so important is obviously this is a fast-moving trial at this point. We're going to be updating you both on air, online. We have our live blog that's going to be updating in real time. So if you have any questions while you're watching our live stream, that's a good place to watch and get some updates.
Yeah, you know, seeing Callie's story there, sort of showing us the overview of what's happened over these last 3 years, again, just shows you how passionate people are on both sides. It's disheartening only because we know very soon here a large group of people will be disappointed. We just don't know on what side.
Yeah, and I think something that's been interesting is seeing some comments on Facebook with people saying, you know, regardless how this comes out, everyone stay peaceful. You know, they're not really hoping for any protests, you know, rioting. You
That's
know,
what we're all hoping for.
Right, and
for sure.
Obviously we cannot tell people what to do in those situations, but that's, I think, a common thing that we're seeing. We're actually seeing proceedings start, and we can actually tap in right now, take a listen.
No, Your Honor. Your Honor, we did file motions. I don't think this is now the time to argue them, but we want to make sure the court has received them. And if the court wants any additional argument on the motions, I'd like to let us know. Otherwise, we're going to rest on our motions themselves, and we're not requesting oral argument on those.
Okay. And I know there was a question that I did not place on the record that we discussed briefly that I should or could be a question on the record, and those were jury questions that were not asked. And I believe specifically when the defendant was testifying, and I was trying to find that particular question. But aside from that, once I locate that, then I'll read it place it on the record. Because I do believe that questions that were not asked should be placed on the record. So what I'll do is just have it. Is the witness ready to retake the stand?
Yes, Your Honor.
And would either side like him sworn in again?
No, Your Honor. Reminder's fine, Your Honor.
So you can retake the stand, and I'll remind you, sir, that you are still under oath.
Thank you, ma'am.
Friday.
Yes, ma'am.
And then we'll have the jurors come in.
I said, not a whole lot of additional questions, but I do want to get at a few things. One of the things you talked about, though, on your direct exam is that you have kind of a network of experts you rely on, because I think one of the questions was Mr. Stoughton or Professor Stoughton and Mr. Bloomfield were not part of your network. Is that a fair statement?
Yes, sir.
Now, when terms of, obviously you get hired as an expert, you're retained to provide testimony, correct?
Yes, sir.
When you give a defendant access to the expert, do you get compensated for that as well?
No,
Is it
sir.
on top of, you get paid for this, do you get paid for
No.
giving them access to these other experts?
No, we don't charge a referral fee in our process, no.
But Mr. Bartel would be part of your network, if you will.
Yes, we would reach out to Mr. Bartel if his CV supported the need, yes.
And Mr. Blake would be part of your network as well.
I don't know that we've ever used Mr. Blake, but I would certainly consider his CV if we needed it, yes.
What about Dr. Kroll? Is Dr. Kroll part of your network?
Dr. Kroll is, yes.
Okay. So in terms of, in this case, did you facilitate, did you reach out to them to say, hey, I got a case for you, kind of?
No.
Okay. But that you provided that information to the defense so they could reach out for this case?
I don't know, I think they had already found them in this case. I don't know that I actually referred them in this particular case.
We talked a little bit about the International Chiefs of Police and the foot pursuit policy.
Yes, sir.
And then, like you said, it's not mandatory, it's adopted, correct?
Right, just to be clear, the foot pursuit considerations paper, I couldn't find an IACP foot pursuit model policy. What I saw was the second resource, which is a considerations paper, but I think that's what you referred to.
But in that considerations paper, they talk about foot pursuits are inherently dangerous, right?
They are, yes.
Do you disagree with that?
No.
One of the things they said, decision to pursue a fleeing suspect should not be regarded as required or even prudent in all circumstances. Do you disagree with that?
I do not disagree with that.
It all depends on the seriousness of the offense, the totality of the circumstances. That's what they talk about, correct?
Yes, sir.
And in terms of, people flee the police for all kinds of reasons, right?
They do.
Some people flee because they curfew violation to a serious felony offense, right?
Yes, sir.
And one of the things, I think it was Eric Heim, the podcast you talked about. Do you recall talking about sometimes innocent people are the most difficult people to deal with because they know you're innocent, you're still trying to figure that out, right?
Yes.
So when you're looking at a chase, it's based on the totality of the circumstances. You would never recommend a single officer chasing 4 armed suspects down an Arc Alley, would you?
Well, if you're talking about the 2 different types of chases, I think we may have discussed chase to pursue or chase to contain or chase to capture. It wouldn't be unusual to chase 4 people. It might be unusual to try to capture them all simultaneously.
So chase to contain is part of the thing. You chase and you're keeping an eye on subjects and calling for backup and trying to get, establish a perimeter, right?
Yes.
All right. We've talked about it, I don't know if you were here, but just the CLIA, just for the record, Commission on Accreditation for Law Enforcement Agencies. You're familiar with that?
I am, yes, sir.
And that's kind of we've heard it, that's the gold standard, if you will.
That's their marketing slogan. I don't know that they're considered the gold standard universally. There's many organizations that do what they do, but I think their marketing slogan is they're the gold standard, yes.
Okay. And it's all, I think we heard that only like 5% of law enforcement agencies ballpark are CLIA accredited.
Yeah, I don't know the percentage.
Okay. But Grand Rapids is CLIA accredited.
They are, yes.
And you're not faulting. I mean, it's a good thing to have accreditation, right?
Yes.
And one of the things that CLIA does is they take a look at comprehensive and uniform written directives that clearly define authority, performance, and responsibilities. That's one of the criteria CLIA uses when they look at a department, right?
Okay, I'm sorry, I did miss that. Will you say that again?
They look at, is there a comprehensive and uniform written directives that clearly define authority, performance, and responsibilities? That's one of the criteria.
I don't know the CLIAs in front of me. I would take your word for it if that's one of their written criteria, yes.
And part of how they do that, though, is they bring in people from departments from all across the country, right? To look at the policies of a specific department.
I don't know that that's their policy, no.
You don't know how it's done? You don't know the process of CLIA?
I know the process of CLIA. The evaluation model, sometimes just a couple of people that have been hired by CLIA, and they would be regional representatives, so I don't know how many or where they get. Typically, I know of one regional representative that will work with the agency. you've listed I think your broader question is, do they pull in people from across the country? I don't know that they do
You don't
that.
know that. Okay. But part of the policy that you cite, though, the policy that's taken a look at is Grand Rapids policy bases the reasonable of any use of force is ordinarily judged on the totality of the circumstances, i.e. based on all of the circumstances. That's clearly Grand Rapids policy.
Correct, yes.
Thank you. I have nothing further, Your Honor.
Thank you.
Morning, Mr. Clean.
Good morning.
On Friday, you were asked some questions about who Force Science has consulted with in this case. And you previously testified you've consulted with defendants, students, community members, and prosecutors. Has the prosecutor's office in this case ever consulted with Force Science?
Yes.
And are you aware of whether the Michigan State Police investigators that are involved in this case has ever attended a Force Science course?
Yes.
Do you recall when approximately we retained Force Science?
I believe ultimately it was September of 2022.
Have you ever met with or talked with Officer Schurr about this case?
No.
Did you have any part in preparing Officer Schurr for his statement?
No.
Thank you.
Just one question. We never consulted with you on this case.
Not on this case, no.
There's been years in the past.
Yes,
Not in this case.
I think there was maybe just 2 in the past, 2017 timeframe.
Thank you. I have nothing further.
Nothing further, Your Honor.
We see a couple of questions on the agenda, so I'll have my clerk come and grab those for you. To clarify, your opinion is based from you looking at everything, videos, audio, reports, autopsy, testimonial, and then human factors, or the other way around?
So we would start with the first. So we would look at the facts of the case, the evidence in the case that was available at the time. So that would be the videos, that would be the audio. And then when we're taking that and we're trying to evaluate the officer's decision-making and performance, that's when we consider the human performance aspects.
And next, when you got drive stun in your head, how long approximately did it take to recuperate?
Well, once I realized that I was okay, it was probably less than 30 seconds. I think the initial shock of it probably took more time than the recovery did.
subject didn't have full control of the taser during the time deadly force was used, would you still consider it a reasonable action? Or is this what makes it reasonable?
Yeah, it's again, the standard I'm using is, could a person in the officer's position, knowing what they knew, reasonably believe? And so we don't look at actual threat, we look at apparent threat based on the available information to the officer. So if we later learned that if the officer reasonably believed he had full control, and later learned that he didn't because we could watch a video or do a still shot, we analyze the case based on the apparent threat from the perception of the officer at the time, not what we would later learn. Yeah, I'll just stop there. I think that answered it.
Any follow-up from that, Ms. Hamilton?
No, Your Honor.
No, Your Honor.
And I don't see any other hands raised from the jury. May this witness be excused? Ms. Hamilton?
Yes, Your Honor.
Any interjection?
And no objection, Your Honor.
Thank you very much, sir. You are excused.
Thank you, ma'am.
And defense, you may call your next witness.
The defense rests, Your Honor.
And Mr. Rebecca, are you prepared to put on any rebuttal evidence?
We do have one brief rebuttal witness, Your Honor.
Okay, you may call that witness.
Call Detective Dupree again.
And since you were sworn previously, I'm not going to have you re-sworn, but I am going to remind you that you are still under oath.
Yes, Your Honor.
Thank you. Whenever you're ready.
Detective, kind of going through, I want to get into one of the things you do is obviously you try and get a statement from the defendant in any cases like this, correct?
Yes, I do.
Let the record reflect that I'm showing opposing counsel exhibits 37 and 38 of these exhibits. Detective, I'm going to show you what has been marked as exhibit 37 for identification purposes. Could you tell the jury what that is?
I'm sorry to interrupt, but 37's already been admitted.
I'm sorry, I thought we had 36.
37 was already admitted.
Okay. Then I got to go 38 and 39.
37 was training record / outline. What it was.
Okay. So let's try exhibit 38. Can you tell the jury what this is?
Yep, this is a typed written statement. It's 3 pages long. It's signed by Chris Schurr on April 15, 2022.
And how did you get this statement?
I requested through his defense. I believe Mr. Dodge facilitated getting this to my office.
Okay. And what you did is after you get this, you turn it over to our office as make it part of the case file, correct?
Yep, this becomes a part of my report.
And I'm going to show you exhibit 39. Could you tell the jury what this is?
Yep, after that original statement, I, along with my colleagues, had a couple of follow-up questions. I numbered those out. I believe it was 13 specific follow-up questions. Purely voluntary, but I reached back out to Mr. Dodge and I asked if Officer Schurr would be willing to answer these follow-up questions, which he did. So this is, again, typed answers to those questions, signed by Chris Schurr on May 13 of 2022. It's 3 pages.
And once again, you made those part of the file as well?
Yes, I did.
I move the admission appeals exhibits 38 and 39.
No, Your Honor. 38 and 39 are now admitted.
And just to be clear, there was not during the interview, this was just typed
Correct.
at some point in time away from you?
Yes.
Just one follow-up thing. Why is the state police investigating this? Happened in the city of Grand Rapids. Why is the state police on this?
Yeah, we have a formal agreement with the Grand Rapids Police Department. Again, I work for the Michigan State Police. And before my time and above my rank, a formal agreement was made with the PD that if they had an officer-involved shooting, that our department goes and investigates those. So really, I was there on invitation based on a formal agreement that was in place ahead of time.
Thank you. Anything further?
Morning, Detective.
Morning, sir.
I just want to ask you some questions about the statement that was just admitted and the circumstances under which they were admitted, under which you obtained them. You touched briefly on this. Now this was obviously a case that drew a lot of attention from the public. Is that fair?
Yes, it is.
And you were among several detectives that were working on this case?
Yes.
And you recognize that Christopher Schurr was under no obligation to give a statement, right?
No, this is purely voluntary.
Okay. And if you, in a normal case, went out to talk to somebody and said, we would like to talk to you, if they said, we don't want to talk to you, then you can't force them to talk to you, right?
No, and that carries no weight with me, the response.
Okay, but you were doing this investigation, there's a lot going on, and you wanted to hear from him, and you reached out to his attorneys, right?
Yes, I did.
Okay. And by that point, he had Mr. Dodge as counsel, right?
Yes.
And I think you said that the first statement was in April 15th of 2022?
Yes.
And that's something that was signed by the defendant?
Yes.
But came through his attorneys?
Yes, it was.
Okay. That's not an interview you had with him shortly after the incident or anything like that?
No, there was no interview.
And in a case like this where there's a shooting, you actually give the officer some time to reflect anyway, right? Before you would try to interview them, right?
That's standard. That's typical.
Okay. So you don't pounce on them like right after the shooting and start asking them questions, right?
If they wanted to, I would not say no, but I've not had that experience with an officer before.
And then you got the statement, you asked some follow-up questions, and you actually wrote questions on the second statement that's dated May 13th. Is that fair?
Yes.
And again, it came through counsel, and to the best of their ability, you believe that you got some answers to the questions you had?
Yes.
Okay. But that's not everything that you might have wanted to ask Officer Schurr, right?
No, sometimes when I'm interviewing somebody, those interviews can go on for hours and hours and hours. This was, if I had to ask some pointing questions, it was a short list.
Okay. And so I think it's 13 questions. That's pales in comparison to the number of questions that he could be asked on, say, like cross-examination, right?
Yes.
Okay, thank you.
No, Your Honor.
On the jury, step down again.
You may, Your Honor.
Any objection?
No, Your Honor.
Thank you very much. You may step down. Any additional?
No additional rebuttal, Your Honor.
All right, so I would like to take a break because looks like the evidence is complete, but we need to go over some things outside of your presence prior to closing arguments. And so I'm going to ask you to go into the back and we'll take a 15-minute break right now. And meanwhile, even though all the evidence is finished, you're not deliberating yet, so I'm going to ask you to still keep your notes and not discuss the case amongst yourselves or with anyone else, and also continue to refrain from any new reports in the media and social media, and then we'll see you back in about 15 minutes. You may be seated. Did my law clerk provide you with a set of the final instructions?
Yes, Your Honor.
Yes, sir.
One on Friday. And we sent over some proposed additions, changes.
I would like to take a break and go in the back to discuss anything that we can discuss as far as hashing out the instructions. I also noted that on the expert witness instruction 5.10, there's several experts that are missing and some that their expertise is misstated. So I'm correcting that particular instruction. But if you want to come in the back and make sure that they're complete, and if there's any objections, we can deal with that when we come back on the record.
Okay, so are you saying that we don't have the final instructions yet?
I'm saying, my law clerk provided you with the final instructions. I noted that there's some things that need to be inserted. I don't have the, Ms. Hamilton mentioned that that you sent something over, I don't know if there were corrections or objections. Either way, I haven't seen those. If they were sent over the weekend or this morning, I have not seen those. So I would like the opportunity to review those before saying these are the absolute final set of instructions.
Okay, Your Honor.
Okay? And then I did know that there were a couple that were missing, so, but I would like the opportunity to address any additions and that sort of thing without having it long, dragged out discussion on record about them. But if you don't want to, that's fine. I just thought it would.
Whatever the court prefers.
I just thought it would be easier.
Just one thing, Your Honor. You didn't ask at least one question. You want to put that on the record before we forget?
Thank you for reminding me about that. So I did want to put the questions that were presented by the jury but not asked of the defendant, and then this particular witness that just stepped down, there were two questions that were not asked of him. As far as the defendant, there was a question by one of the jurors that we did not ask him, which is, and that's after discussing at a sidebar, and that is, has your wife ever asked you to get something from a different area of your house? When you don't find it, does she take your word for it, or does she go check herself? That was not asked. Also, did you speak to anyone about the incident between April 2nd and when the statement was submitted? That was not asked. And also not asked is, did anyone offer their suggestions or advice on how to write the statement? So those were questions that were not asked of the defendant because they were found not to be appropriate to do so. And then of this particular witness, there were two questions that were not asked. The first is, can you explain your thought on body cam from Becker's reference? That was not asked. And then, have you ever testified in a case for the prosecution where the police officer was found guilty? If so, how many? That was also not asked. And I believe those are all the questions that needed to be placed on the record that were from the jury, not asked, but needed to still be placed on the record. I do have all of the jury questions, and I've noted with an X the ones that were not asked and check mark the ones that were. So that will be part of the file. And is there anything else before we recess briefly to go over these instructions?
Nothing, Your Honor. No, Your Honor.
So we'll recess briefly for that happens. All right, please.
So again, what you are seeing is the most recent session proceedings in court, a very short one compared to the ones that we've seen earlier last week.
Yeah, absolutely. And just to give everyone a quick recap of how things are working for us, we've been doing this from day one, and this is the case for all media covering this trial. We're on that 30-minute delay. So of course, what you're seeing happened 30 minutes prior, and so we're now waiting for court to go back in session from that short recess that they took.
And I believe we are expecting closing arguments are going to be happening soon. We can't say specifically when, but as we have heard from Andrew, the only thing that was standing in the way of closing arguments from starting was having the defense close its case, a rebuttal, which as you saw, Prosecutor Becker did do that very briefly, and now it seems like they can begin those closing arguments. Not sure when that's going to happen.
Or how long that will be. Again, in our conversation with Andrew, he says sometimes judges will put limits on those in terms of just how long they can go. Sometimes not. So, again, we are nearing the end of this trial, but we still don't know just how much longer we have to go. As you said, we still have those closing arguments. And then, of course, the jury will have to deliberate. It's not as if we'll have an answer just like that.
Definitely. And I think what will be interesting to see is how both sides kind of refer back to their opening statements. If you remember Prosecutor Becker's opening statement, he said, you're going to hear from this witness who's going to talk about use of force. You're going to hear from people from that day. You're going to hear from, other experts that are going to talk about police tactics. And we saw that, same with the defense. We saw a very bold opening statement for them talking about put the taser down. And we heard that actually throughout the trial with the video.
Yeah, many, many times having to watch that now infamous video of that traffic stop, which isn't easy to watch. I know even at some point in court, Chris Becker even said, I know we've got audio on this video, but we've heard it enough. We don't need to hear it at this point. So yes, that's something that has just been replayed, and you went back to those opening statements. You know, as we spoke with one of our experts, Tanya, about this case, I thought it was so important that she pointed out, this is not something that we would consider a complex case, because we know that Christopher Schurr did shoot Patrick Lyoya and that caused his death. But again, going back to those opening statements where both sides have stood from the very beginning is, was this shooting justified? I remember in the opening arguments for prosecution, them saying, hey, in this case, you will hear things to suggest that Patrick Lyoya did do some things wrong. There were some things he did that maybe should have even led to an arrest. You will hear that he had been maybe drinking and driving that day, things that certainly are not a good look on his character. But the argument from the prosecution from the beginning has been that it still did not justify him being killed. Of course, conversely, on the other side with the defense, they're saying Christopher Schurr did everything right that day. He was doing his job and feared for his life, and therefore was justified in the shooting.
It'll be interesting to see if they bring up the taser again during their closing statements. If you remember, you saw Prosecutor Becker pick up a taser that was used still in the bag during his opening statements. But then you also saw the defense actually grab a taser. I don't think it was a specific one, but a version of it, and kind of walk with the jury and kind of show it as they're speaking. So, and we have seen the discussion of taser throughout this whole entire trial. So I'm curious to see if they're gonna wrap these closing arguments up with the taser again. Will they bring it back to kind of reiterate the focus that they have? Or are they gonna let that, not be part of it?
Yeah, you're right, because that has been such a central focus point of this trial. And I want to be clear in that, referencing what Tanya said about this case and it not being complex. Of course it's complex.
Yeah.
We don't know the correct answer to how things will end here, but what she meant in that was, we know those answers, how he died, what caused his death. The complexity comes in even just with that taser, as you said. I mean, this was a shooting death by gun, and yet that taser is playing such a focal point in this court case. I mean, they talk about, where was the taser at the time of the shooting? In what position was Patrick Lyoya possibly grabbing for that taser, or was he holding the taser at the time of the incident? But then people have even gone into that argument and said, okay, well, he may have been touching it, but was he touching it or holding it in a way that he could have actually caused any danger? So yes, again, to your point, this taser is such a big part of the argument. And another thing making this case somewhat complex are the questions that just can't easily be answered. I know that has come up as well with witness testimony, that no one can truly speak to Christopher Schurr's state of mind at the time of that incident, which why, it was so interesting and important that we saw Christopher Schurr take the stand, and you heard him say himself, I wanted people to hear my side. I wanted people to hear from me my side of the story.
It's gonna be interesting to see if we're able to, as journalists, be able to talk to jurors, the defense, the prosecution after this. Obviously, it is up to the jurors that they decide they want to speak to the media. They're not required to. But you have seen in other cases where they have, even if they kept their identity hidden, they still have said, what was going through their mind. And like Tanya and Andrew have said, just the way that the defense and prosecution has created their case, built their case, and continued their case throughout this whole entire trial, I think it would be interesting to hear from them as to why they made the decisions that they made. Is there some regret of how they did certain things? Are they glad things went a certain way? And obviously, I think, again, what will maybe put in a different aspect to this trial is whether or not only is he found guilty or not guilty for second-degree murder, but also manslaughter. Obviously, that is on the table possibly for this trial. If second degree was the only charge on this case, would have that made a bigger change of how they created their case? Or is it almost kind of like a fallback to say, okay, well, For the defense, we have, 2 hurdles to kind of wait and see if we can jump over. For the prosecution, it's 2 hurdles that we have to attack that hope that either one of those lands. So it'll be interesting to see.
And we've been hearing from the jury already. We talked about this with Andrew earlier. This is not unique. He cleared this up for us last week. This is not necessarily unique to the state of Michigan, because in this state, that is allowed. Jurors, if the judge allows it, can ask questions during the trial. Judge Mims has allowed that in this case, and so we've seen those questions incorporated throughout the trial. Now, we're not hearing the jurors' voices, but they are then able to pass their questions up to the front for the judge to then read the questions she deems relevant or appropriate enough to be read aloud. I know that there are some questions she has said are not relevant or, shouldn't be read aloud, but once she then decides which one she does want to read aloud, we have heard from the jurors, and I do just find that so interesting, because many times it is just sort of a mystery of what is going on in their minds, and we still don't know that, but we're getting some insight just from the questions that they're asking. Of course, still don't know what direction they're leaning in.
And I'm curious if the ability to ask questions, did that impact how they decided what they did? If you're not able to ask a question and you have to make a decision based off information you're given, that can be, you can think one way because of the information in front of you, but if you're able to ask questions, does that broaden what you're thinking? Maybe makes things more complicated for you or solidify things. And also too, we have to remember that these are 12, 14 jurors that have to all come to an agreement. So it's gonna be interesting to see how each juror is thinking about this case. You may have a couple that are dead set on one way and others who are smack dab in the middle and others who are on the other side. And they'll have to come together and come to, I'm not sure if it's a complete unanimous vote, but they have to come to an agreement all together. So it'll be interesting to see how even just specific jurors are taking this case.
Well, yeah, and I mean, if we are ever able to hear from them, I know one question that will be on my mind is, which witnesses weigh more heavily on you? Which were the witnesses that truly did stick out to you, that their story or their interpretation of the story is maybe what helped change their mind one way or the other? I mean, of course, that has been the meat of this case, is just hearing the different perspectives from the witnesses, some of which, there were some objections, of course, specifically on the prosecution side. We had witnesses that talked about different use of force policies within the police department, but that's where some of the questions were coming in, where the defense was objecting, saying, hey, they're speaking to general policing policies, not specifically Grand Rapids policing policies. And as a matter of fact, I know that was one of the questions that the judge did not read to the court, because there was a question from one of the jurors asking, well, hey, what policy should we be basing this decision off of? Is it Grand Rapids police policy or general, policing policies across the country? And the judge actually said that was a question she decided not to share, because she said she will make the instructions very clear once it's that time what they should be basing their decision off of.
And I think what's also important to remember is that these jurors were both selected by the prosecution and defense. I think that there were some people who were frustrated or confused as to what the makeup is. Obviously, we know the majority of the jurors are women. A lot of people on the jury with a background in the healthcare system. So I think what people need to remember is when they're asking those questions that you present, they do have to remember that both the defense and prosecution had to approve this jury pool. And so, you can't say that one side was able to get this trial pushed through one way or versus the other side. Both of them had to approve, and they did approve this jury pool.
Right, because that was a process in itself,
Yeah.
Of course, choosing the jurors and the 2 alternate jurors that are, serving for this case. And we talked about that in the beginning, how I believe it was Andrew who said, typically cases like this we're seeing on your screen now, the makeup of the jurors, of course, we don't know their identities. We won't know their identities, but this is the information that we do know about them. And when we spoke with Andrew, the legal expert we've been working with covering this trial, he said typically for a criminal case like this, they'd have a jury pool of about 50 to 60 people. Instead, we know they pull from some 200 people to choose this jury because we already knew this is a high-profile case. It had been in the media for 3 years now. It's pretty hard to come across someone here in the area who has not heard about this. But we also heard from one of our experts, Tanya, who said hearing about the case wouldn't necessarily disqualify you from being a juror. Having already made a decision about what was right or wrong in this case is what would have disqualified someone. So yes, again, just interesting to your point. There have been lots of comments and opinions about the makeup of the jury, but that's a whole process in itself that, as you said, both the prosecution and defense work together on choosing this group.
I know some people are always worried that because for us, for 13 on Your Side, for example, we've been streaming this, I think sometimes 7 to 8 hours a day all last week. There, you can hear the judge give specific instructions to the jury every single day saying, do not look at the media, do not, leave your notes covered. So for those who are ever worried, like, oh, we saw an expert say this, is that gonna sway a juror to think a certain way? They have been instructed to not look at the media or to look at anything that's going to give them an idea to, basically, they stay in the trial. Right. Everything that is surrounded around this trial is in that courtroom on their notes. And so no one needs to worry that a juror may be looking at, 13 on Your Side thinking, oh, I could think this way.
Right. I mean, because even important to point out, there are moments in the trial that jurors are asked to leave the room because something is being discussed that they are not privy to. So there are multiple times that they are asked to get up and return to the courtroom based on what they can and cannot hear. And important to keep that in mind as you're watching our stream as well, that while we do have access to bring this to you on that 30-minute delay, the court and the judge are still very much in control of just what we can show. So there are times on our stream that you won't hear any audio. The microphones are all muted because even as court proceedings are going forward, there are times that the judge says, no, the public cannot hear this, or the jury should not hear this part.
Yeah, most definitely. So we're hopefully getting close to when we're able to bring back those proceedings. I'm trying to look on our blog to see if we're getting any updates. As of right now, we have not gotten any updates into whether we're able to bring those proceedings back. I'm trying to look for you all.
Yeah, of course, a lot has already happened this morning in such a short time. Now, typically, court proceedings have gotten underway at around 8:30 each morning. We luckily knew ahead of time that they were starting on a bit of a delay this morning, and so that already sort of put us behind. I think they got started around 9 as opposed to 8:30.
Yeah.
But within, 30 minutes, we'd already started to see things move forward. Of course, Chris Becker had gotten cut off on his cross-examination of the last witness Friday. I believe that's where they started this morning, but didn't last long before the defense rested shortly into getting into proceedings this morning. So that's where we are now. I believe Chris Becker already did his rebuttal, which was a short part of the process. So we're waiting now to see where things pick up. Are we going to be going into those closing arguments?
And I know that a lot of people, one of the main focuses of this trial is actually hearing from Schurr. We have some sound queued up for people to listen. Take a listen right now.
First, is the safety on the taser an on-off switch, or does it need to be held in the on position?
Good question. It's called a safety switch. It's an on-off. It's like a light switch. So it was on, I switched it on. It actually is some tension. I don't know the amount of weight to turn it on or off, but once it's on, it's on. It takes actual decent amount of physical pressure to shut it off.
And next, does writing a statement or a police report require you to write in the moment of the incident or for accuracy of what happened?
I think I get what.
Was right in the moment.
Yeah, I would. All right, if I answer that, I think I know what they're. If I understand the question correctly, I feel like there's a. I guess what I've been trained to do, there's kind of a difference in some part of it you're using the video, and then parts they have you just kind of go more or less off your memory for different various portions.
And the next question, in the beginning of the video, when the subject assaulted you prior to running away, at that time, is it okay within GRPD policy to use a taser prior to the tackle or in place of the tackle?
So that's kind of a loaded, to answer that. The strike could potentially justify under GRPD policy the use of the taser. However, using it on a subject that's running away, causing them to lock up and fall, especially around concrete vehicles, they hit their head, they could die using it or applying it in that manner, if that answers that question. So typically we're not trained to use it on someone who's running.
Well, the question asked about prior to running away, so as you
Oh, prior,
that
well,
you were on concrete, so.
Well, I think he starts to run at that point, so.
Well, the
I
question
think-
is prior, in the beginning, when the subject assaulted you prior to running away, at that time, is it okay?
Oh, prior to running,
use the
actually
taser?
physically running? I would say yes, but the amount of time it takes me to get my radio out, he's already running at that point, so then we're in that same situation that I was discussing, if that makes sense. The actual, I think it would be petty to deploy a taser for what he did. That, for me, that's my opinion, based on just that information.
Okay, next, did you feel at any time prior to you presenting and deploying your taser that the subject was trying to grab or obtain the taser or any other weapons on your belt?
Was the question prior to?
Did you feel at any time prior to you presenting and deploying your taser, the subject was trying to grab or obtain the taser or any other weapons on your belt?
Prior to deploying the taser, I didn't feel as though he was trying to grab any weapons.
Next, do you recall being able to smell alcohol on Mr. Leoya during your first interactions?
No.
Next, when you say you saw the taser being held as a handgun by Leoya, did you prioritize attempting to press on the safety or to turn the safety off or to remove the taser?
The entire goal was to get the taser back. I couldn't get it back. The only thing I could potentially get my fingertips on was the safety at that point.
I know I asked about alcohol during your first interaction, but at any point did you notice he was under the influence?
I didn't smell it or notice it in those moments. Based on his actions, I would believe it, but I wouldn't just say because of him not responding to some of the tactics automatically means that he was under the influence. So I guess the answer is no.
Next, when you write a statement or police report, what is the process?
Depends on the report. If it's a more involved report, we'll review video as much as we can, and then type it, and it might go back and forth.
Do you require running through new scenarios each time a new model taser is introduced?
You definitely do different you do scenarios when you get a new taser, for sure. However, when it might be the same scenario, when we switched to the new model, the bigger thing was the effectiveness at close range because of the design of the cartridges itself. So, and we didn't have to worry, the way the cartridges were designed were better for close, we didn't have to, I don't want to get into the actual design because I can't remember the original taser. I hardly remember the one that I used in this, but the big thing was it was more effective at close range and to train to use it in that manner.
Next is, why do you shoot Mr. Leoya in the head?
I wouldn't say that I was necessarily aiming per se. I only had essentially a viewpoint of his upper back and head area. I deployed my handgun and fired it in that direction. It ended up hitting and striking his head.
Mr. Dodge, did you have any follow-up questions from any of those?
I do not, Your Honor.
Mr. Becker, how about you?
I have none, Your Honor.
I don't see any other hands. Oh, there's one hand raised on the jury. Next question is, when is running a license plate allowed? Is driving too slow reason enough?
To my knowledge, we can just drive around and run license plates whenever we want. And to answer just driving too slow, I guess potentially driving too slow depending on the speed limit you're in. And I guess if you are exceedingly below the speed limit, yes, that is a traffic violation. That wasn't necessarily what I was stopping him for that day.
And again, that is the jury being able to ask questions to Schurr. The first time we've been able to hear from him in basically 3 years, kind of his perspective of everything. We want to let people know who are watching. Obviously, we are still in that 30-mandated delay. We have gotten word that the prosecution has put down a motion to include second-degree manslaughter as among the charges. We're also hearing that the defense is asking that not be included. That's something Andrew said there's a huge possibility that could be included. Obviously, it's up to the judge who can say yes or no, but we already kind of assume that that would happen.
That would be part of this. And we asked Andrew, well, what is the difference? He mentioned that would be a really long explanation. He said the important thing to keep in mind is more so the penalty and the differences there, because I believe he said with that second degree murder conviction that there could be life in sentence or life in prison, or as many years as the judge wants to give as a sentence. I think he mentioned 100 to 200 years. I think he said a life sentence itself is a mandatory 25 before you can go on with any other, issues at that point. But what's important is that he said for that manslaughter charge, the difference there is that the maximum penalty would be 15 years. That's a large difference when you talk about hundreds of years or a life sentence for that second degree murder charge.
And we have just gotten word that the judge has approved for the secondary manslaughter charge to be included into the jury's deliberations. So again, kind of widening what could really happen. Could Schurr, be facing up to life in prison? Could he be facing up to 15 years in prison? Obviously, I can imagine if you're hearing the possibility of life versus 15 years, someone may choose 15 years, mostly wanting to not be in jail at all. But I wonder if that changes how the defense goes forward with their closing arguments. Now that they've spent their whole trial debating second-degree murder. Mm-hmm. Now they have second-degree manslaughter. How do they bring that into their closing arguments?
Yeah, such a great question. And Andrew, the legal expert that we've been talking to over this trial, also broke down the actual process that jurors will go through now that they do have those two different options. I thought it was interesting. He was saying that first they will have to just look at the second-degree murder charge and decide how they feel about that. Should they decide to convict on that, that's where it ends. But if they don't decide to convict on the second-degree murder, now they've got that additional opportunity to then look at manslaughter and decide, do they want to convict there? But I thought it was interesting him explaining that there's a process there. They're not going to just go in and start deliberating, okay, do we want manslaughter, do we want second degree? They've got to start with the second-degree charge first.
And I want to ask my producer, Eric, can you once again just run back what you just said about Okay, so we just got word that the judge has now made a more tailor-made definition of self-defense specifically for police. Again, we're obviously just getting these updates just now, so we don't know how that will play into the continuation of the trial. But again, changes are constantly coming in this trial, which, you know, what looked very different even just earlier today.
Yeah, that's right. I mean, remember, court just got in session here about an hour ago at this point because they had a bit of a late start this morning. They started around 9, I think. But yes, so interesting to see how these things are playing out. You remember we started this process just last week. We didn't know how long court would be going on, and now here we are approaching those closing arguments, which could be minutes away. We still don't really know.
Yeah, and we're still obviously trying to get updates. I'm going to check out our blog that Riley Mack has been keeping updated for us all day long. I believe she's saying similar things that we've already said. Yes, the prosecution asking the judge to include a lesser charge, that voluntary manslaughter, which for her definition says voluntary manslaughter means a person killed another person unlawfully but without premeditation. Defense has argued to deny this charge and the judge has ruled to allow it. So again, that kind of already falls into what we've seen. Obviously, we know that second degree, do not quote me about it being premeditated, but clearly they, like the attorneys that we've spoken to before have said, this trial is not about whether or not Schurr killed Patrick Loyola.
We know that already.
We already know that. What it comes down to, and maybe specifically for this charge, is, you know, he killed someone unlawfully, but without premeditation. Does that fall into what the defense has already argued in the prosecution, or does that fall out of line? That's something that these jurors now have to think about.
And again, Lauren is reading from our live blog. We're doing everything we can to make it so that you can follow along with what's happening in this trial, not only with our stream that we've been bringing you every single day as this trial has been ongoing, but as well as this live blog that you're seeing there that's on our website, 13 on Your Side. We've had our Riley Mack and Callie Lichter at the courthouse every single day that trial has been in session. They're the ones helping our team really be the eyes and ears of what's happening inside the courtroom, because of course, as we have been streaming that for you, we've been saying it all week, we are on that court mandated 30-minute delay. That's the case for all media wanting to cover this case. So we've been doing the best we can to bring you all the information you need so that if you're at work or, you know, you can't turn on a video, you can still follow along with exactly what's happening, again, using that live blog on our website, or if you can watch a video, you can tune in to our stream where we're trying to bring you that recap and speak with live experts to talk about what's happening in this trial.
Most definitely. And for those who are watching, curious about where Riley and Callie are in the courthouse, they're in a specific room that's been designated just for the media, not on the same level as the actual courtroom, but on a different level, but inside the courthouse. And that's just essentially just kind of just break things up. You know, obviously, people who are inside the courtroom and people in the public can go in the courtroom. It's a public case. But people who are inside the courtroom can see the jury, kind of get a more closer look at the atmosphere. But obviously those who are in the media room are essentially watching what we're watching and are not able to see all those things. But again, it's interesting to hear even just their perspective of physically being in the courtroom, you know, getting a sense of people maybe walking up to the courtroom, the courthouse, and just kind of being actually in the building.
Yeah, and the atmosphere of all of this with all of the buildup, 3 years to this court case. And at some points, we didn't even know if this trial would happen just based off of the appeals and whatnot. So such a big buildup to this moment. And like you mentioned, yes, that courtroom is open to the public, but we're talking a really small courtroom, 44 seats. and I believe 16 of those or so were reserved just for the Loyola and Schurr family. So about 28 open to the public, a really small amount of the public able to walk in, and people were having to line up pretty early outside the courthouse, the Kent County Courthouse, for those who were wanting a seat. We were seeing people show up as early as 5 a.m. with doors opening at about 6:30 every morning to let those members of the public who were lining up into the courthouse. We were live out there on day one. I think that's when we really saw the most activity, at least early in the morning, with supporters on both sides showing up around 6 in the morning, holding signs. And so, you know, I know that there have been supporters out there every day of the court outside of that Kent County Courthouse. The first day, though, people had really, it seems, been anticipating that this was happening, so much so they were there first thing in the morning. I know a lot of people anticipating what will things look like once we do hear that verdict, because as I've said, a large group of people is going to be really disappointed. We just don't know which side yet.
Yeah, and we are getting some more updates as this goes on. We have just learned that the defense is now also putting in some motions in regards to taking out some expert witnesses. Again, that's something we've already seen before, kind of really going against the prosecution. We also learned that the jury is now actually back in the room, so could mean that closing arguments are well underway, will be hopefully coming soon. But to go back to your point, you know, I've been here in the afternoon for this case, and we have definitely, especially on Friday, seen people actually seem like they come back to the courthouse at the end of the day. Especially on Friday, there was a large, not a super large, but definitely a number of people from both sides of support at the courthouse. You can actually hear them chanting behind Callie and Riley as they're going live during our shows, and definitely a lot of support on social media as well. So it's definitely been interesting to see what time people decide to come. You know, we saw, like you said, early on the first day, people were ready, lined up, ready to go. That kind of trickled down, but then maybe in the afternoon they came back. But interesting to see how people are continuing to support both sides.
Yeah, a lot of passion on both sides. You're seeing that outside of the courthouse with these ready-made signs. I was really sort of taken aback by that first day of the trial, just how prepared people were. We weren't seeing signs with just Sharpies, you know, to write their messages. These were signs that had been pre-made to let you know, hey, they were planning for this and they came ready to show their support. So it sounds like we are ready to turn things back over.
Let's take a listen.
I hope we aren't getting calloused. And callousing is the fact that how many times do we watch a video of another person, Patrick, dying over and over and over again? It wasn't TV, it's not movies. This is a real man, a human being, who was shot in the back of the head back in April of 2022. We watch it over and over. He's got a family, he's got loved ones. So I hope we're not callous, it's just something we see because we somewhat get immune to somebody dying over and over and over again. And we try and take a rational kind of look at it. And I think the other thing, when you look at it, it's a serious crime, but it's got one of the more simple elements, if you will. Because it boils down to just a few elements. There's a lot of other crimes you're not aware of, but elements are what we have to prove beyond a reasonable doubt. And so when it starts off, we talked about over and over again, this is the first element. Patrick died because of a gunshot wound to the head that the defendant did to him. And so that the other part is, yes, this is also about him, about what he did. Because Patrick is no saint. I'm not going to sit here and argue Patrick was a saint. He was drunk driving. He was resisting. He was driving without a driver's license. None of those are executable offenses. There are ways to deal with it. It's just because he committed a felony. He could commit 20 felonies. He could have had other felonies. It doesn't mean he deserved to die or he has to die. That's for juries. That's for other things down the road. The other thing is, I'm not going to sit here and say he's a horrible person. Yeah, he's got a great family. We heard about how he's an All-American, grew up in Grand Rapids. Yeah, that's wonderful. That's great. Relevant. Because you don't compare, okay, one's good, one's bad, we'll just throw it up there. You have to base the case based on the facts. You'll hear from the judge that sympathy or prejudice shouldn't play any role in your decision. So you've got to base your decision on the facts that were here, the facts that were what the witnesses said, the videos, all the policies and procedures. That's what you have to base it on. Not, well, he's a hometown boy and want to do good, and we've got this bad guy who's drunk driving. It's not that simple. It is simple in terms of the elements, though. Clearly, the defendant killed Patrick back in April, and he had an intent to do so. Because part of the instruction you hear, there's maybe 3 different states of mind, but I'm going to stop at the first one. There was an intent to kill, and the intent to kill. Please don't get wrapped up. Nobody's saying that when we left that morning that he intended to kill somebody. When he fired the shot, he intended to kill. That is clear when you put a bullet in somebody's back of somebody's head. So in terms of the elements they have to prove, the first 2 are proven, no question in your mind. Those are the 2. It's those are the easy ones. So what does it come down to? Why are we here? Number 3. Number 3, was the killing justified or excused or reduced to a lesser crime? That is your decision. That is why you're here. And justified, I talked a little bit of cross the line clean. Words matter. And words matter in terms of it matter, we're gonna hear a lot of instructions, and sometimes jurors get wrapped up in terms of instructions that, this is the law, and we're in a courtroom, and somehow things change because you're in a courtroom. You don't lose your collective common sense. You'll hear that instruction from the judge. You have your own common sense, you have your experiences. The words that you use out there have the same meaning here. Justified, done for a good and a legitimate reason. Excused, removing the something you had to do. You're excused from school. You have a duty to go to school. You're excused from school. You're removed. So what is the duty here? You have a duty not to kill somebody unless it's a really darn good reason. That's the duty you have here. That's the duty any of us have here. There's no difference between a police officer or a civilian. You can't take a life without a darn good reason. So when you start looking at that, when you start getting into the evidence, I think there's maybe also a little bit of confusion in terms of the law. What is the law? Okay? What is the law, and the law impacting the policy? Because you've heard that. There's the policy of GRPD. You have to follow the law. Okay? The judge will tell you your job is to follow the law policy, and what the policy is, in fact, may impact how you interpret the law and what happened here. But you have to follow the law. So the law on the left, the defendant must have honestly and reasonably, once again, words have meanings, honestly and reasonably. It can be 2 different things. You kind of think of the same thing, but you can have an honest belief, but it's not reasonable, right? There's a lot of people that believe that have an honest belief. We never landed on the moon. It was a big hoax. Nobody landed on the moon. We made it up. There's a sound stage somewhere in California that we made up a moon landing. It's an honest belief. Is it reasonable? So a lot of what depends on is what is reasonable. And what is reasonable is also defined. And there's 2, you'll see the same thing. You have the policy of GRPD is not vastly different from what the law is. You kind of take a look at the reasonable person under same or similar circumstances, looking at the totality of the circumstances, looking at everything that happened. What led up to that decision to fire that shot? You have to take in everything from the start to the finish. And it's got to be reasonable through the entire time. We've heard that testified to on a number of different occasions. So you have to, what is the reasonableness when you break it down? And once again, dealing with the facts of what was presented here today, here this week, that the time you've been paying attention to. Well, maybe putting it another way, it was reasonable to shoot Patrick because he had the taser, he was outnumbered and exhausted. That's really the justification. That's the excuse. Okay? And that's an important thing because it's not that he pointed the taser. Nobody said that. The defendant took the stand, can't say that in a statement, never said he pointed the taser at me. He simply had the taser. That's it. The best we could get at was, maybe he was starting to turn and he thought he may be pointing at him. No evidence, never said he threatened it, said he was going to use it, that I was going to kill you, said anything like that. He simply had the taser as one of the justifications of why I had to shoot. And the other one is, he was exhausted and alone, outnumbered. So, kind of taking that second one, let's take a look at that second one going from that perspective. Okay, why? Why were we in that situation? Well, that goes back to the chase. There's no dispute that, the defendant had the absolute right to try and place him under arrest. Okay? He was driving without a license. And that's the thing you have to look at it. At the time, he knew driving without a license and had a bad plate. Those are the only 2 reasons. Okay? There's nothing else. Nothing else that the defendant knew at that point in time. So you have to take it at that point in time. That's what he knew. Didn't know about the drinking, that came up later. So at the time, he makes the decision to chase, and I'm not gonna play the videos, we've seen it ad nauseum, and that's a great thing now. You can go back in the jury room and play those. You can look at whatever you want, you have the ability to replay it, take different looks at it, pick whatever thing you want. Please, take a look at it, go over it. You paid attention, but now you get to really talk about it. So the decision to chase happens, and he makes the tackle, okay? He makes the tackle on that, well, within a minute, that's when he's tired. He's exhausted and outnumbered. That's one of the first things he says in the statement. He's exhausted and outnumbered within a minute. Now, mind you, how, at 1 minute, this is one of the best fit officers in the Grand Rapids Police Department. And he's exhausted and tired within a minute? Well, apparently they should never chase anybody then, if that's the circumstances. And we're not saying, though, that police can never chase anybody. It's based on the totality of the facts and circumstances. And in this case, look at what's going on here. We talked about the use of force 9-1.5, relative size and stature, multiple subjects, relative strength, access to weapons. All those point against that decision. Because from the get-go, he knew he gets higher, he knew he was bigger. We all, we heard from the testimony of Captain Cyber, we saw how he moved, got jumped off, kind of moved when he spun. Got lifted off the ground. He was we didn't know he had access to weapons. That's a scary thing, because how many times over and over again did we hear about Grand Rapids Police talking about traffic stops, unknown traffic stops? You have to anticipate there are guns in the car. You have to anticipate that the people with the car in the car may have a weapon. But we have a person flying off chasing, not knowing about the guns, not knowing about there's another person, knowing this person's bigger and stronger, and yet doing that. But then using it to turn around and saying, well, I'm outnumbered and I'm exhausted because I chased somebody. That's troubling. That's troubling to use that as a justification from the get-go. There's plenty of policy, and that's why we talk over and over again, Exhibit 36. That's the one policy we see, a set out policy. If you're looking at policy, how does that impact the law? That policy says, hey, if somebody's armed and dangerous, you're perfectly fine in following behind, having a plan, not tackling. It's bad tactics to tackle. And I thought it was ironic that, in terms we brought that up, that the defense then brings up, well, they're trying to chase. And they have to go over chases, but the chase that they talk about in Exhibit 31, they bring it up, you're responding to assist in a foot pursuit. Solo officer gave his last location and no further updates. You're first on the scene to assist. And what does that talk about? The officer's in trouble. The solo officer's in trouble, and so you've got to assist this officer in, he got himself bit off more than he could chew, which is essentially what happened here. So yeah, they train and you can chase, but it's basically you don't go running off. Von Queen says, yeah, I'm not going to advocate somebody go running off and chasing people down a dark alley. You're outnumbered, there's no business. When you don't know the situation, call for backup and do that. But now they try and use that as justification of why this all happened. The next part, the next major part, is the taser. You grab the taser. Okay? And these are screenshots. These are some frozen screenshots from the frame-by-frame video that you have an opportunity to take a look at. When you look at the frame-by-frame, this right here, the one on the left, is you can see the taser. That's when the moment the taser comes out. This is a little bit further behind because it's just about to be deployed, because you see the two dots on it. You hear from Nick Bloomfield in terms of that's where the shots are going to go at that point in time. So when the grabbing of it during this period of time, what's going on? Why would you make it? And Nick Bloomfield's the one that says, well, yeah, you can use the taser, but you got a whole big issue with weapons retention right here. And you see why. You see why is because that's exactly what happened. He grabbed onto it. He grabbed onto it right then because he's face to face. But once again, you get back up. It's not like you just look at it in silos. What did we talk about before? What did we talk about the criteria, if you will? Patrick's still stronger. Patrick's still don't know if he's got weapons. You're still outnumbered at this point in time. You're actually sticking, you're trying to stick a gun where this guy who you just tackled, had two hands on, were on top of, gets up and walks away, and now you're trying to hold on to him with one hand, and then deploying the taser at the same time, and that's gonna be a good idea. And so this is, we have experts, this is Mr. Bloomfield saying, yeah, that's not a good idea. And you kind of see why that happened, but it also, once again, talks about policy going against, what does TASER say? This is from the PowerPoint. We go over the PowerPoint. Here's what TASER says about it, is that, employ other force options or disengage. Okay? So, Patrick did a bunch of dumb, bad things, but that, the defendant did some things that led to this firing a shot, and he's using those as justifications. Well, this all happened, ergo, I get to use deadly force. And that's where you get into Professor Stoughton and Nick Bloomfield. They're the ones, they don't disagree with everything that happened here. Yeah, you can get pulled over. Yeah, he had a right to arrest. When in these certain critical areas, there are critical mistakes that occurred here that a reasonable officer, not using 2020, a reasonable officer wouldn't have made those same decisions. You don't try and chase him as bigger instructor. You don't try and bring a taser out holding on to with one hand in a position where he can grab the weapon, especially when taser says, yeah, you can disengage, and the ideal footage that somebody has to use for a taser is 4 feet, even with the closed cartridges. Because we went over that. A closed cartridge, yeah, this Taser 7 had the ability to use closed cartridge, but closed is 4 feet, not an arm's length, which led to all this. So looking at the totality of the circumstances, you justify, well, I used a taser, I chased somebody, so I had to use, and I shouldn't have, but I had to kill him. That's essentially what they're arguing. So one of the things you also have to look at is the imminent threat analysis. And this is kind of interesting because one of the things you hear in terms of all the witnesses, the experts on both sides, Von Clean and Professor Stoughton on both sides, they kind of use the same analysis, right? They talked about this. The imminent threat means intent, opportunity. Okay? I think there's a motive. I think Von Clean had motive. There's a similar thing. So if you think about that, when does Patrick do an imminent threat? When does it happen? Once again, you just don't. Use the defendant's statement because okay, he didn't testify to this, but take a look at his statements. Those are exhibits 39, 38, 39. The last two things I just admitted. Because when you go back and I cross-examined on him in terms of what did he think was going on, what was going on at the time, Patrick's trying to get away. Because these are his statements. He began to walk away. He proceeded to turn away. He ran away from the stop. He would not comply with commands and continue. I think the last two are the key. Continue to move his arms and legs in an attempt to get away. From the get-go, all this time before the taser grab, he's got the idea, yeah, Patrick's trying to get away. That's the defendant's perspective. That's what he says in his statement back in April of 2022. Okay, Patrick's not threatening me. Patrick's not taking a swing at me. Patrick's trying to get away. That's the whole basis. Even when it comes to the taser. And that's the thing, that's the key moment, okay? That's where something more is happening here. He puts his hand on the taser. What is the defendant's impression? The defendant's impression is he moved it so he'd not be struck. And that also compares when you think about, you start comparing, you compare the witnesses. What do the other witnesses say? What does Wayne Butler, the neighbor? Wayne says from the get-go, yeah, Patrick's trying to get away. Wayne says, yeah, he's trying not to get tased. That's the whole thing. That's not an expert. That's just a normal civilian. A neighbor sitting there watching everything. He's not trying to get tased. You can tell that. That's a lot of what Seth and Professor Stoughton and Nick talk about. There's an intent to flee. There's no intent to harm. There's no assault going on here. He's trying to get away. You don't get to shoot somebody because they're trying to get away. That's not a justification. That's not an excuse. That's what the law is. And that's what the impression of everybody here, including the defendant, because that's a statement. So when you start looking at it, has the ability to have an intent to do great bodily harm. That's the imminent threat analysis. When does that start? Was it here? Because once again, you get to look at the pictures now, because right here, clearly, that one on the far side, he's moving away from him. That's obvious to everybody. So why now, just because he's got his hand on the taser, is he going to use it against him? He never threatened him. He's never tried to swing at him. And you go back to these. Look at the first two. He's got plenty of opportunity, right? He's arm's length away. Both hands are open. Take a swing, punch, do something. Grab the taser, get away from him. So once again, how does a reasonable officer in this situation think I'm going to die?
when a guy who's done nothing more than keep trying to get away from you, to keep trying to walk away from this? How does a reasonable officer get that out of this? And then you go to, and these are exhibits from the body cam, or excuse me, the cell phone video. You hear about, Professor Stone and Nick talk about, their opinion, based on generally accepted police practices, was that a reasonable officer in this situation would not make the decision to fire. And what do they say? One of the reasons is, well, he was never in a good tactical, Patrick was never in a good tactical situation. And look at this. This is a good tactical situation when you're on the ground. He's on his back. Take a look at it. He's flat on his back with the taser at his side. Okay? He's not. And once again, what does Wayne say? Wayne kind of says the same thing. Wayne's not, once again, not an expert, saying he's winning. The defendant's winning, I think he said. There's nothing coming from Patrick. Okay? Right here, this is the one thing they point to. Right here, just before the shot was fired, his legs get lifted off. His legs get lifted off the ground, but within a little over 10 seconds, he's back on the ground. So you break it up. So until the taser's grabbed, we have the defendant saying, yep, he's trying to get away. What happened in the next minute, 10 seconds approximately, that would make a reasonable officer think he was going to die? What did Patrick do? What did he do? He grabbed on the taser. That's the sole justification. He grabbed on the taser. Didn't point, didn't threaten, didn't say anything else. Once again, didn't throw any punches, didn't do anything like that. So why is a reasonable officer going to think, and that's exactly what Professor Stone and Nick said, a reasonable officer wouldn't have come to that conclusion. Generally accepted police practices, and generally accepted police practices are Grand Rapids policy. Because we heard that from who? Captain Cyber and Captain Pierce, who basically said, we're CALEA certified. We're certified by CALEA. They give us, that's generally accepted police practices. That's, you have other agencies come in and take a look at things, and generally police practices, and that's what Professor Stone and Nick based their decision on, based their opinion on, when you take a look at all these facts and circumstances. Why would a reasonable officer think he's going to die when somebody's simply trying to get away, never in a tactical situation by their opinion, and as well as the civilian witness who saw it at the same time? So it also comes into this part. I'm trying to play it, hopefully it works as long as it never.
Let go of him! No, that ain't good. You can't talk to him.
Because that was one of the bases. That was the basis of Nick. Nick Bloomfield said, well, the other thing on top of it, the taser there was no neuromuscular incapacitation. That was not possible because right there, because that's the second. And Brian Child says, there's the second deployment. So it's been deployed twice. There was no probes that were going to fire out at that point in time. So he couldn't have been incapacitated. Well, they call it, David Blake saying, what the heck's going on? We need to, he doesn't hear anything, there's tunnel vision, he's going to skip things and miss things. And his explanation at this point in time is, well, he could have, been out of breath. Listen to it and watch. Drop the tape, and then he moves it away as well. There's plenty of knowledge that he knew exactly what would happen, but you also take a look at everything else. And you look at everything else, what happened there, what else? All these other things that he heard through this entire incident. Take a look once again at his statement. He heard everything. He heard the neighbor coming out of the house at the beginning. That's when the fight's still on. He heard that he didn't hear him, but that's still hearing, other units were on the way. He could not hear sirens later on. After the taser struggle, he knew that there were no sirens coming, that other cars were approaching. So he heard everything, and suddenly there's just one thing he misses, and that's on top of all the other perceptions he was making at that point in time. He saw, this is, he testified, here, he saw the red on the taser on what was happening. So when you look at all that, he was aware of anything, so suddenly this one thing he missed, that he wasn't aware that that taser had been deployed twice, so there's no chance of neuromuscular incapacitation. You have to ask yourself that. How is that possible? One thing, you just missed one thing out of everything he perceived. He perceived at the moment he fired the shot, in his statement, he says, yep, I checked the background, there's nothing there. So it's not like he says, I don't remember what happened. He says, yep, I was checking everything, I saw everything, I heard everything through this entire incident. So there's knowledge there
that the taser was not able to be fired that would cause NMI. And the fact that it's suddenly maybe the NMI, that it could have caused pain, we heard over and over again. How many times did we hear from the various defense witnesses? Were you tased? Yeah, oh, it was painful. It was painful as heck. It was, it was burning, it was, everything. Pain is not a reason to use deadly force. You can't use deadly force because you're going to be in pain. There's no instruction. You can use deadly force when you think you're going to be killed or you're going to be seriously injured. Pain is not part of that. Just because it's going to cause you a lot of pain. Burning the pain of 1,000 burning suns doesn't justify it. But they try and work that in now. And they try and add that in. And quite frankly, look at his statement. That was never the concern back when he wrote his statement back in April. The statement was he was afraid that he was going to get tased, there's going to be neuromuscular incapacitation, and then Patrick was going to grab his gun. It wasn't the taser that was causing the issue, it was the fact that he may get shot. So NMI said it, and some Patrick's going to grab his gun. Why would you think Patrick's going to grab his gun? Patrick never went for his gun. They testified, never touched his gun, never tried to go after his gun, never grabbed his gun. But that was the feeling at the time. Which also going into policy, if you're trying to determine what policies should have an impact, you heard over and over again, what was the policy in 2020? Exhaust all alternatives before firing. Now I thought that's kind of interesting in terms of, what they talk about. They keep on saying, well, in terms of, if you make the decision to use deadly force, does that mean you have to go back down? That's not nobody's arguing that. Like I said, if, during one of the witnesses, if somebody comes out with a gun and points it at you, you don't have to try and use pressure points, right? Nobody's saying that. But when you're in terms of a struggle over that lasts a couple, 2-3 minutes, yeah, you got to try something else. And what do we have here? We have arm strike, one arm strike, a bunch of knee strikes, taser gun. What does JRPD teach on this? Why are we going over that? 4 hours, they're recertified. That's where you take a look at the exhibits, all the training records. They are taught for every year, going over all the pressure points, all the different stuns, all the different strikes, all the different things that are used to try and get control over a person who's not willing to be arrested. You don't need to use all this stuff. You don't need to do stuns and takedowns and pressure points. You don't need to grab somebody by the side of the jaw if they're compliant, right? You only do that is when they're not compliant. None of them are used. Zero. Not one. So what is the purpose of this policy that says exhaust reasonable alternatives when nothing happens? They don't use it, it's ignored, doesn't even try. Arm strike, kick, taser gun. That's all we have here. And then that's part of the policy we talk about, require a warning shot. Now they say, well, it doesn't make a whole lot of sense that maybe stop is enough. Maybe stop is, we don't say stop or shoot, but there's some sort of warning, so we kept on saying you drop the taser, that's enough. That seems that once again flies in the face of the policy that says is a warning shot must be given, or a warning shot, warning must be given before firing the shot after you exhaust all reasonable alternatives. None of them were exhausted. There was no really warning. It was just a shot in the back of the head from a guy who was trying nothing more than to get away. There was no threat there. He wanted to get away. Whatever reason, he wanted to get away. We don't know why. We don't know why he made that decision. He was drunk. That could have played a role. But that didn't mean he should die on that day. So when you look at it, a lot of what we are basing on, yeah, it's two experts. Our two experts, Professor Stone and Nick Bloomfield. And they based it on generally accepted police practices. What would reasonable officers do under this situation? And when you look at it, they take a look at the whole thing. As you look at it, there's I think Professor Stone said, yeah, there's an imminent threat. A reasonable officer would think there's an imminent threat of somebody trying to get away, but that's very different than an imminent threat of somebody trying to kill or hurt or injure somebody. Those are two different things. And once again, that's also backed up when the one civilian who really saw everything here, Wayne Butler, he kind of said the same thing. There was no evidence that Patrick was trying to hurt or do anything. He was trying to get away. The primary act was resistance, an attempt to hit harm, and he didn't do harm. I think that's an important thing. There's a fight to the death, and that's why I showed those pictures. There's a fight to the death, and the most injured, you got maybe some redness on his wrist. You're in a fight to the death, and they keep on talking about a fight. how's a fight? Once again, a fight is defined as, throwing punches, doing something else. This was a wrestling match. The most I could say, all the witnesses say this was active aggression. Okay? He was pulling away, he was wrestling. The only thing we could say is, well, potentially, maybe, the defendant thought maybe he was gonna turn and fire the taser. There was never a tactical advantage, that's what they said, never a tactical advantage, so why would you think that you need to do it at the moment and fire that shot? Because what had happened over and over again? You saw Patrick tried to get up once, defendant shoved it down. Patrick got up again, what did he do? He walked away. So this time when Patrick's trying to get up again, he gets shoved down. Watch the video, take a look at that video. He gets shoved down again. He never got up, fully walked around the second time after they went to the ground on the taser. They were wrestling, Patrick went to get up, he was shoved on the ground, and that's when the fatal shot was fired. The defendant had tactical control, the defendant was on top of him the entire time. Why would you think you need to use deadly force under these circumstances? So what happens? If it's not reasonable, it's not lawful self-defense. That's the only thing that justifies it. That's the only way we get out of here without a verdict of guilty under these situations. There's not a reasonable officer that think that Patrick was trying to kill him based on what was here. So what does that mean? The defendant's guilty. This was a traffic stop. At the time the defendant knew what was going on. It was for a bad plate and no driver's license. What out of all this made him think he was going to die? He had his taser? That's not enough. He was tired? Yeah, he was tired. That would be great. You don't need to beat over the head that he was tired. He was tired because he put himself in that situation. There was no reasonable officer that would think he was going to die based on the facts and circumstances here. So the verdict that he must come at the end is guilty of second-degree murder, and that's what I ask you to return the verdict of such. Thank you.
All right, Mr. Bordello.
Thank you, Your Honor.
Good morning, everyone. And thank you for your patience. The prosecutor is trying to make this case something it's not. You're here because you're going to judge my client, Christopher Schurr, on the decision of whether or not to use deadly force in a situation, on his decision and his belief that he was in fear of either great bodily harm or death. You are not here to judge the GRPD policy. You are not here to judge whether it was reasonable for him to chase Patrick Leola. You have to decide whether the prosecutor has proven beyond a reasonable doubt, whether Grand Rapids Police Department Officer Christopher Schurr had a reasonable fear of great bodily harm or death. That is the issue. And you must look at it as to at the moment of the threat. When Patrick Leola had the taser in his right hand, whether or not Christopher Schurr was reasonably in fear. And the prosecutor has failed miserably. I want you to look at just the case that the prosecutor put on. And I would submit to you, the prosecutor didn't even meet his burden in their case. You heard from a couple of Patrick Leola's friends about what occurred the night before leading up to the events. There was a night of drinking. Mr. Leola wakes up at 8 a.m. according to the witnesses who were there. He's with Aime Tuyasheme and David Bakuru. And the prosecutor put on evidence of how much everybody was drinking. That was the prosecutor's case. and that they got into a car. No one is suggesting that anybody should be executed because they're drinking and driving. That's absurd. And that's nothing to do with what happened here. Yes, he was drinking and driving. Is that a bad thing? Yes, but nobody's saying they deserve to be executed, and nothing like that happened. The issue is whether or not he was in fear after Patrick Loyola later on took his taser. So what happened is they get into a car, and it has a license plate from a different car. That means that the license plate belonged to a totally different car. Mr. Loyola and Mr. Tuyashime and another person was dropped off so that person could take his kid to school, and then they drive around. They visit Mr. Loyola's new apartment. They stop to reload on Budweiser, and they're driving around again. When, according to Mr. Tuyashime, they hear a noise in the car, and they were driving around. They take a couple right turns. They stopped on Griggs Street in Grand Rapids. And then Mr. Loyola quickly exits the car to see what's going on. According to Mr. Tuyashime, he really wanted to hear what the noise was to try to figure out how maybe there was something wrong with the car. But at precisely that moment, in an incredible coincidence, that's when Officer Schurr had pulled him over. You can decide whether or not that was the case, whether or not that's even relevant. But Officer Schurr, it's irrefutable and undisputable, he had a valid reason to pull him over. The plates didn't match the car. He's a police officer, and that's his job. He's at work. It's 8 a.m. on Monday. That's his job. That's why he's pulling him over. And the prosecutor agrees it's a lawful stop. After getting out of the car, Officer Schurr gets alarmed. You can hear it in his voice. He orders him back in the car. 4 times, get back in the car, get back in the car. Why is he doing that? Because he's trained that if somebody jumps out of their car, that could be a problem. So he orders him back in the car, and Mr. Loyola refuses. Officer Schurr doesn't know why. He doesn't know why he won't go back in the car, but he just approaches him. But he doesn't know anything about a broken down car, because did you hear Mr. Loyola say anything about, hey, my car's not working? There's a funny noise. No. So we're talking about the knowledge and in the situation of the officer here. So what does he know? He just knows somebody jumped out of the car. Instead of answering lawful questions, which the officer is allowed to do, Mr. Loyola decides to start questioning the officer. What'd I do wrong? And then Officer Schurr is asking questions at the same time. Neither are getting answers. Officer Schurr, he says, you have a license. What for? Do you have a license? For what? Do you have a license? What'd I do? Do you have a driver's license? Do you speak English? Because now he's wondering, maybe he doesn't understand what I'm saying. Mr. Loyola answers that question, yes. Can I see your license? What did I do wrong? And then Officer Schurr just starts answering his questions. He tells him, well, the plate doesn't belong in the car. That's why I pulled you over. He's hoping to get an answer from Mr. Loyola. Do you have a license or no? Do you have a driver's license? Yes. Where is it? It's in the car. Get it for me. What did I do wrong? The plate does not belong in the car. He answers his question again. Police officers are supposed to ask questions at a traffic stop. They're supposed to get your ID. That's what a traffic stop is. And that's what he's doing here. And if you want to see how Officer Schurr responds when somebody actually complies in the smallest amount of way, watch this interaction. Look at his body language. Listen to the tone of his voice. When Patrick Loyola says, it's in the car, get it for me. Does he scream at him? No. He steps back, literally steps back, get it for me. So what follows after this is a series of decisions by both of them. Patrick Loyola is making decisions. Officer Schurr is responding to those decisions and making decisions of his own based on his training as a police officer. He's doing his job. Patrick Lloyd decides to walk away from police. Why? We don't know. Officer Schurr is trained, though, that failure to comply, ask yourself why. There's not a lot of good reasons for doing what he did. So he's alarmed again. So he went from, get it for me, please, to, oh, here we go. He's walking away, so I have to go back up. He decides he's walked away, I'm gonna have to arrest him. Why? Because as a police officer, he's committed a crime. And it's not his job to decide who gets set free and who gets arrested. His job is to arrest. He is on the street to detect crimes and arrest people for them. And it's committed right in his presence. He doesn't think, well, I'm not really gonna arrest this guy today. That's not his job. So then you saw that Mr. Loyola, after Officer Schurr lawfully went to arrest him, resisted arrest. And we can argue about all day whether he affirmatively punched him, but balling up your fist and throwing arms like this, I agree he didn't face up to him that many times, just a couple times. He shoves him, and then he decides to run. Why is he running? Officer Schurr doesn't know. He doesn't even know his name at this point. Officer Schurr does his job. He calls it in immediately. Gets on his walkie-talkie. All right, somebody's running, and he catches him. He's arresting him. Feet from the car. Why? Because he's a police officer, and that's his job. He's doing exactly what we expect him to do. He doesn't get to decide, well, I'm just going to let this person go. That's an option under his training, but he made the choice to pursue him. And Professor Stoughton agreed that the initial pursuit was fine. He's just mad that he disagrees with the fact that he didn't peel off once he got near on the other side of the car. And you saw that Patrick Lloyd continued to resist arrest. He lifts him off the ground. Why? Yeah, he's getting away. But Officer Schurr is not trained to figure out what the motive was for the fact that he's resisting arrest. He's just resisting arrest. He doesn't have time to ask him questions. Why? Please just stop. He's not answering anything that he's saying. He's telling him to stop. So Officer Schurr decides to use greater force because he's a police officer and that's how he's trained to handle it. Knee strikes, commands, open hand blows. You heard that they were open hand. So he's not trying to hurt him permanently. He's using his open hand. That's how he's trained. And obviously, they're not effective. He didn't take out a stick and hit him on the head or anything like that. He's trying to arrest him. That's why he's using intermediate force. He's trying to get him to command, to comply with within the bounds of his training. Then you see Patrick Lloyd, he decides to get up and walk across the lawn with the officer in tow. Officer Schurr doesn't know why, but it's not his idea to go that way. Who's in control of this situation? He gets up. He walks him across the yard. Intermediate force didn't work. You hear Mr. Loyola yell, "Get the keys." Well, sure looks like he's developing a plan to get out of there. So Officer Schurr has decided, oh, he just wants to get in his car and go away, so I'll just let him go. No. It's his job to arrest people that are committing crimes. He can't just decide, well, I have to let him go now, because he's saying he just wants to get his keys and get out of here. The suspect doesn't get to decide when you get arrested. So he pulls out his taser. That's the next step up. It's perfect. Everybody agrees it's perfectly appropriate to use intermediate force here. Fires the taser. As everybody agrees, Mr. Loyola grabs it and moves it to the side. That was Mr. Loyola's decision. That wasn't the officer's. He didn't say grab the taser because he put it in front of him. This is not an affirmative act of aggression, reaching out. He grabbed it and he never let go. And he tries to get it from Chris. And look what the officer's decision here was. Did he pull out his gun? No. Did he go to deadly force here? No. He decides to physically try to get it back. He's got the taser in his possession. He won't let it go. And Patrick Loyola decides he's not giving it back. The officer's yelling at him to drop the taser. Let go of the taser. And then the fight is on. They both want the taser. That's what they're fighting over. And Officer Schurr has a right to it, and Patrick Loyola does not. And Officer Schurr did not use deadly force to get back the taser. That is not why we're here. They go to the ground, and the film goes in and out because Mr. Tuyashime I'm sorry, Your Honor, is there something wrong with the camera?
The screen went out for a moment. It's back on now.
Thank you. So you see this part of what's going on. They're both still trying to get it back. And you notice that there's a part where it starts in Mr. Loyola's left hand. And then it's in his right hand. And 11 seconds go by. And you can't really see what happens. So we don't really know how Mr. Loyola got it in his right hand, but we know it was in his right hand. And then you see Mr. Loyola roll over onto his stomach. Just like previously by Mr. Butler's house. He started on his stomach, pulls his knees in, and gets up. And that's exactly what's going on here. The taser is now in his right hand. Officer Schurr's trying to get the taser back still, and he can't. It's been switched. He's got exclusive control of it. He's on his back, yes, but why is he on his back? Because he's trying to get the taser back. And then you see Officer Schurr still trying to get the taser back. He's over the top trying to get this thing back. And you can see on the exhibit that it is in Mr. Loyola's right hand. Right there. These slides, half a second apart. Half a second. This is how quick this is happening. It's a literal split second. Patrick Loyola has got it, holding it in his right hand. It appears from the video, it's consistent with the officer's testimony that he's holding it like a gun. It's clear in the video that it appears that Officer Schurr is being lifted up. Is he jumping up? No, he's being lifted up by Mr. Loyola. And the angle is turning, consistent with the officer's testimony. And here, this is no longer about arrest. This is the decision you have to judge. Whether in the moment of the threat, he was afraid of that taser, capacitation or great bodily harm. Whether it was reasonable for him to make the decision he never wanted to make that morning. Christopher Schurr was at work, And he was faced with the toughest decision of his life in half a second. That's what you're judging. Whether it was reasonable in that split second for him to think that an officer could be in fear of the taser. Not whether, what did Patrick Loyola intend to do with it? He's holding it like a gun, and he's getting up. He has no idea why Patrick Loyola is fighting this hard, and he doesn't have time to figure it out. 3 years later, when you hear about his family and his friends, yes, maybe you can draw some conclusions about what he was actually thinking. But he doesn't have the luxury. He's got half a second to make up his mind. And at this point, Mr. Loyola has given him absolutely no reason whatsoever for him to believe he's not going to use it to get away. It doesn't matter why he's got held like a trigger. I mean, if he's just trying to get away, he's still going to disable the officer to get away. So here we are in a criminal trial. And so now you're asked to judge not what the best practice was, but whether or not in the moment of the threat, whether the prosecutor, with his burden, proved to you beyond reasonable doubt, all reasonable doubt, that he wasn't in fear. And to help you decide this issue, the prosecutor brought in some experts. You heard from Mr. Childs, Professor Stoughton, Mr. Bloomfield, because he is trying to prove to you beyond a reasonable doubt that it was unreasonable for Christopher Schurr to be in fear, beyond a reasonable doubt. And you heard from Mr. Childs. He works at Axon. It's the company that makes the taser. So he is an expert in tasers. A taser is a weapon. That's how they refer to it. And it's something to fear. The taser can cause incapacitation, even if the probes are discharged. If used improperly, a taser can blind or possibly even kill you. Probes can be reactivated once fired if they're lying on the ground. All you do is hit the button again. The wires can cause, even with wires, they can cause NMI, this incapacitation. They're insulated, but it's not a big insulation. It can get scraped off, especially if they're being dragged across the ground. The very next witness is Professor Stoughton. And followed him as Mr. Bloomfield. They wrote a joint report. And they've never heard of Brian Childs. Not really sure who he is. Didn't consider his opinions about the taser. How is that possible? They just flew in, gave their opinion, and flew out. It was their opinion. It's reasonable to use deadly force if going to be incapacitated. So they agreed. If you're going to be incapacitated and you're a police officer, you can use deadly force. It's reasonable to use deadly force if you're going to suffer great bodily harm. You don't have to lose an eye before using deadly force. That's what that means. But then here's where it differs. No objectively reasonable officer could be in fear of incapacitation from the taser, because no reasonable officer could have feared incapacitation or great bodily harm in this particular situation. In other words, the taser is not dangerous in this situation. So you heard from Brian Childs, and then you heard from Professor Stoughton and Mr. Bloomfield. And they completely disagree with the prosecutor's own expert on tasers. They say a taser is not a weapon or something to fear in this situation. The taser cannot cause incapacitation if both probes are discharged. It's unreasonable to think the probes can be reactivated after being fired. Wires cannot cause incapacitation if insulated, because it's so unlikely. The taser is about as dangerous as a thumb in your eye. And even Mr. Bloomfield admitted, unless you're holding it like a gun. So you have the prosecution's own experts disagree with each other. You know what this picture is right here? That's reasonable doubt. You don't have to go any further. They're disagreeing with each other on the basis for why he should or should not be in fear. How can you convict someone for acting unreasonably and not being in fear when their own experts disagree? And certainly not beyond a reasonable doubt. Now, Mr. Stoughton and Bloomfield offer some more opinions. They admit they don't know how he's trained. And they essentially admit that there's no bearing on the ultimate issue of whether he reasonably could have used deadly force. But it has no bearing. These other opinions about the chase and the staying too close. Why are we discussing this? You're asked to determine whether or not the prosecution has proved beyond a reasonable doubt that he was in fear at the moment of the threat, and then whether it was reasonable. Why are we talking about GRPD chase policy? Because they're trying to distract you from the actual issue. And even if you consider it, I mean, it doesn't matter if he chased him improperly. It doesn't matter if he's within 4 feet or 7 feet. And it doesn't matter if he used a compound sentence in his warning or is just a directive. The issue is reasonable fear. And that's why you saw this evidence about tasers and this training. They just don't agree with each other. You don't have to go any further. The prosecutor is also suggesting that you should just let him get away. Let him go. He hadn't punched him. That's the standard for when you get to use deadly force? Well, up to now, I know he just took my taser, he's holding it in his right hand, but he hadn't punched me yet. So therefore, no reasonable officer would think that he was going to use the taser on him. None. That's what they're saying. That's what Professor Stoughton said. It's absurd. Not one officer, no reasonable officer. That's what he's saying. No one could think they were in fear. No one could think that he might use it on them. He's got to figure out that he's got some innocent motive for taking the taser from him after getting up 3 times before. Watch the video. If this issue, does he run away once the taser comes out, or does he turn around and grab it? Does he deflect it, or does he hold on? If it's just some reflex, oh, I don't want to get tased, you just deflect it. Does he ever say, hey, don't tase me? Does he throw it away once he has it? Does he listen to anything Officer Schurr is begging him to do? Is it transferred from his left to right hand? Why would any reasonable officer think he was going to walk away politely? In the split second that Chris had to decide whether or not he poses an imminent threat, all he knows is he's fighting to retain control. He knows he's lost the taser. He knows that he's turning and rising. His fear is unreasonable? No reasonable officer could think that. You should find him not guilty after the government's case. And even though we're under no obligation to put on evidence, because his entire life is on the line, we put on substantial evidence that the prosecutor cannot show that his fear was unreasonable. We're constantly hitting these shifting arguments. You heard from the training officers. Captains, Cyber, McCursey. You saw a lot of training materials. Why is this relevant? Because you're considering the knowledge of the officer, not generally accepted police practices. They may coincide from time to time, but you're looking at what, he's a street cop. He's trained. Hours and hours of training. You saw a lot about taser training. Why are you seeing this? Because this is what's in his head of what happens when you get hit with a taser. I mean, is there any doubt that the training puts the fear of God in these guys about these tasers? They're weapons. You heard about firearms training, deadly force scenarios. One of you asked if they have implicit bias training. They do. This is a heavily trained department. And what is the point of all this training? Let me tell you about training. Officers are put in situations like this all the time, and you train because when you don't have time to make a reasoned decision with all the facts about everybody, you rely on your training. So when the time comes, you have to make a decision, you can act quickly. The same thing in military drills, sports, if you ever played sports, what do? You practice. So it comes almost automatic. When you don't have time to think in stressful situations, you rely on your training. All right, Captain Cyber, he's a training officer, expert on GRPD policy and training. He testified that Officer Schurr trained on GRPD policies and trainings, not generally accepted police practices. Followed GRPD policy and training in the situation. Once a decision was made to use deadly force, he's not required to try other options. It's the decision to use deadly force. A reasonable officer in this situation could have used deadly force. Mr. Becker, question that Captain Cyber didn't do an expert report. This does not matter at all. It's irrelevant whether or not he did an expert report. He was paid exactly $0. I know you heard a lot of paid experts. Captain Cyber isn't one of them. Captain McCursey. He's an expert in GRPD training and tasers. What did he tell you? Officer Schurr was given warnings that taser is a dangerous weapon. If someone gets your weapon, assume they're going to use it against you. A taser can incapacitate you and probe or drive stun. An officer does not have to wait before being harmed or killed before resorting to deadly force. And a reasonable GRPD officer in this situation could have used deadly force. He followed his training. The captains in the GRPD believe that he was reasonable in this situation. Now, let's talk about the prosecutors' experts on GRPD training. Here they are. None. So everything that involves his knowledge, you heard from the defense, and nothing from the prosecution. How did they show you he didn't follow his training? They didn't call a single GRPD officer. You know why he didn't call one? It's his burden to put on proof. Ask that question yourself. How else has the prosecution failed to meet its burden? We heard about exhaustion. Heard from Lombartel. It's reasonable for an officer in Schurr's position to lose ability to continue fighting. In a fight, you lose ability to contract muscles within 30 seconds. He was in a position of tactical disadvantage, not advantage. He fought with him for 2.5 minutes with a man that was larger than him. He's got nothing less, and he lost control of his taser. Or from Dr. Kroll, he wins the award for the smartest witness. He's a biomedical scientist. Why are we calling him? Because we're trying to refute this testimony by Professor Stoughton, who is not a taser expert, that you can't be incapacitated by this thing. So if you think that Professor Stoughton actually knows more than Mr. Childs, we called another expert. Drive stun can temporarily incapacitate you through disorientation. You have the probes and then you have the drive stun. A scientist came and told you, yes, you can be temporarily incapacitated. And Professor Stoughton agrees, if you can be incapacitated and you're in fear of incapacitation, you can use deadly force. The drive stun can and has caused great bodily harm to sensitive areas. You heard this whole thing from Professor Stoughton. There's no reported deaths of police officers who lost their tasers as officers trained after they lost their tasers where someone took their gun and killed them. And you know why? You also heard that answer from Dr. Kroll. Because officers are trained to use deadly force if someone gets your taser. That's why. He told you how many deaths there were. You heard from Dave Blake. Well, you first heard from Mr. Bloomfield that this is not the type of situation where auditory exclusion and tunnel vision or this sort of closing in, it's not stressful enough. And then he was asked, are you an expert in human factors? Well, no. Well, this is Dave Blake, he is. He said this is exactly the type of case where this could occur. And that Chris did not have time to give a warning. That's it. That's how much time he's got to make up his mind. That's what you're judging him on. And that decision, not whether he chased him a minute and a half before, that's how much time he's got to decide, and whether that was reasonable under those circumstances. The prosecution suggests that you shouldn't credit Dr. Blake's testimony because he went to an online school. But yet, he wants you to credit Mr. Bloomfield's testimony, even though he didn't go to school for this. I'll let you decide who's more credible. So you heard from the use of force experts. They pretty much agree on a lot of stuff. We agree on the standard as trained. When you're in fear of great bodily harm or death, that means they can't you're not worried about a paper cut. It's got to be like stabbing, breaking a bone, or losing an eye. And of course, death. And if the prosecutor could show beyond a reasonable doubt that he wasn't in fear at that moment, that's the standard. You heard about the totality of circumstances. And you can go through these. These are the things you're supposed to consider when reviewing whether or not the decision to use deadly force was appropriate. And we agree that a lot of these things applied. But that doesn't mean he shouldn't have tried to arrest him in the first place. This just means, under the totality of circumstances, the decision to use deadly force was reasonable. You know what's not on there? Foot chases. Because it doesn't matter. It's the decision to use deadly force that you have to consider. And he was bigger than him. There were multiple people. He was stronger than him. He got his taser. He's in a bad tactical position, or if you believe Professor Stoughton, he's in a better tactical position. The fitness level, the exhaustion, it's raining. He's getting up with the taser in his hand, and he's right next to him. All these factors point to a positive decision to use deadly force. You heard from Officer Gady. He's a firearms instructor. It's deadly force is deadly force. All the experts agree on this. It's the decision to use deadly force that you're judging, not the location of the shot. Not one expert said, oh, you have to try to wing him or hit him in the hand or hit him in the side. That is not what these experts are saying. It's the decision. Am I in fear of imminent threat? Is there an imminent threat? Then I can use deadly force. The manner of deadly force doesn't matter, and everybody agrees to that. Where do they disagree? Well, you heard that the prosecutor's taser expert and the prosecutor's use of force experts disagree. And you also heard that their use of force experts didn't really rely on GRPD policies and Michigan law. Instead, they have this generally accepted police practices. And that's because Professor Stoughton and Mr. Bloomfield, they're viewing this in hindsight, and everybody agrees you shouldn't do that. It's a sort of a woulda, coulda, shoulda thing. If you go back in the jury room and say, you know, if he just had let him go, that is not the proper analysis. I wish he just, I guarantee Christopher Schurr wishes, in hindsight, that he had let him go. He didn't want to make this decision. That's exactly what the prosecution is doing here. Monday morning quarterback, based on all kinds of issues that don't matter. It's the moment of the threat. Look at his training, his knowledge, what he knew. And you take that into that situation and you decide that based on what was in his head, the decision to use deadly force was reasonable. In this case, they have to prove beyond a reasonable doubt that it was unreasonable. Now you heard Chris testify. He had no obligation to testify. It's a criminal case. What did he tell you? He testified about his knowledge, his training and experience. He was exhausted, running on fumes. He was alone. He called it in right away, but there's nobody there. You can listen to the video. Do you hear any sirens at the moment of the threat? Listen to it. Crickets. Where is everybody? He testified he did everything he could to avoid using deadly force. He didn't pull out his gun as soon as he grabbed the taser. Probably could have under this training. He tried to get it back. And he's screaming at the guy, let go of the taser. It's the moment of the threat. He testified that he saw the firearm. Let's get that. In his hand. He was trying to he testified he tried to put the safety on, even. Couldn't do it. He's in a bad position. He does not feel like he's safe. He's pulling himself up again, and look at what Mr. Lloyd had done 3 times prior. Literally lifted him off the ground, and now this time he's got the taser. It's reasonable for an officer to think in that situation that he's going to use it on him. It would be unreasonable for him to think he wasn't. But when he's given a chance, he comes into the stand to cross-examine him as vigorously as he did Captain Cyber. He barely even asks him about the moment of the threat. What does he ask him about? You didn't have to chase him, right? That's the questions they got. You stand too close to him. You're in really good shape, aren't you? That's just designed to mislead you from the issue that is why you're here. He suggests that he's lying about the second pop because he said, look at the statement. Did he ask him about hearing it? Nope. He just wants you to look at a statement that was done. As Christopher Schurr testified, I kind of wrote it like a police report after seeing the video. I mean, this video was out there right away. That wasn't his fault. And then you have the state police asking for a statement, and he's got counsel already. And he signed it, so it's attributable to him. But keep that in mind. You know, view the actual evidence, the testimony. The prosecutor has a chance to ask him all these questions. Now he asks you to answer based solely on a statement that was written with the help of lawyers a few weeks after the incident. That's not fair. He didn't have to testify, he did, and then he didn't ask him any questions. How can you assess his credibility on these issues when he wouldn't even ask the questions? All you're left with was what he said originally, but it wasn't the focus of cross-examination. No, it's something he wrote kind of like a police report because he's a police officer. And look at this exhibit right here. If you're wondering whether he's exhausted, I know he's in good shape, but 2.5 minutes trying to wrangle a grown man, desperately trying to get a taser back, is not the same thing as running on a treadmill. So you're going to hear about the law, and I think I have already stated over and over again what the issue is. Nowhere in here will it say, please consider whether or not Officer Schurr's complied with policy. Nowhere in it will say, hey, maybe we should change GRPD's foot policy. Please give us your thoughts on that. No. That's a distraction. Go to the next one. The relevant consideration is not what defendants should have known or done, but rather what a reasonable officer with the knowledge and the situation of the arresting officer could have believed at the moment the officer made the decision to use deadly force. That's why we're here. Professor Stoughton and Mr. Bloomfield say it was no reasonable officer could have thought he was in fear. We don't think that prosecutions come close to meeting that burden. If you start discussing whether or not GRPD should have a foot pursuit policy, stop, because that's not relevant. Look at the moment of the decision. It's the decision. Please, just look at the decision and whether or not there is enough there for any reasonable officer to think he might be in fear of harm. You're going to hear also that police officers do not have a duty to retreat. And this is important because private citizens do. Like if he wasn't a police officer and you saw this, then yeah, he put himself in a position he shouldn't be in. But Officer Schurr, he's not supposed to be retreating. He doesn't have a duty to retreat because he's a police officer. He put himself in danger, yes, because that's his job. You heard from one of the officers about the cowardice policy, just letting people go. You have to be sure that he wasn't in fear of great bodily harm or death before you can convict him of murder. Now, if we go to the next one, please. Honestly, or go back, I'm sorry. Wow. One more. It has to be an honest and reasonable belief. But you heard from Officer Schurr. Judge him on his testimony. And judge his testimony in comparison to what you saw in evidence from the video. You heard him say that Mr. Leoya had exclusive control of the taser, and he did. You heard him say that he was completely exhausted after a minute, and you saw how he was 4 minutes after. And if there's any question whether he feared that taser, whether he had an honest belief, if he doesn't fear it, ask yourself, why is he trying to get it back? What is he, even after the second discharge? Does he stop for a second and slow down after that second probe goes? No, he's still going gangbusters trying to get it back. Why would you turn the safety on if it's as dangerous as a thumb? It doesn't matter what Professor Stoughton thinks about thumbs and tasers. It matters what he thinks. And look at the video. Does he slow down for a second? He's fighting as hard as he can to get that thing back. He's going over the top of him. He's putting himself at harm. Yes, because he's trying to get it back. Reasonable? This is what the prosecutor thinks is reasonable. No reasonable officer could have thought that that taser, with the probes discharged, could harm him, could incapacitate him. None, not one. These guys who didn't even talk to the taser expert for the prosecution, who disagrees with that completely. If no reasonable officer could have been in harm or thought he could be incapacitated, then why does everybody else that's called to the stand think you could, including taser experts? Especially when handled by an untrained person. Now you're going to hear a separate jury instruction on manslaughter. It's the first time you're hearing this. This is the prosecution recognizing this case is weak. It's a lesser included. It's for cases where someone didn't intend to shoot the gun. Officer, he got up there and he told you, yeah, I intended to use deadly force. I intended to shoot him. But it was justified because he had the taser and I was in fear. This is not a situation where someone gets in a fight and they don't really intend to kill him, but they lose their cool in the heat of passion before they have time to cool off. They kill someone and didn't really intend it. That's a lesser included. That's not this case. And justification of self-defense is a defense to both of them. So if you find that the prosecutor hasn't met his burden to show that he was unreasonably in fear, then you must acquit to both of them. You absolutely cannot convict him of murder or manslaughter if you acquit him of murder. Now, you've heard a lot about the burden of proof. And it's important. It's a criminal case. It's not a civil case. I think a lot of you were asked during the voir dire whether, it's got to be one of the it's one of the most important decisions of your life, like buying a house. I agree. It's got to be, this decision is as important as those. And this is the highest burden under the law. I like to equate it to, you have a friend, family member who's on life support and you have to decide whether or not to take them off life support. That's how important this decision is. It's any reasonable doubt. Now, the wiggle room in there is if it's not reasonable. If it's an unreasonable doubt, then that's not something you should consider. It has to be a reasonable doubt. If you have any sliver of reasonable doubt, then you must acquit. They have to prove beyond a reasonable doubt that he wasn't in fear and that his use of deadly force was unreasonable. If you're back to saying, well, he might have been justified, you must acquit. He could have been justified. Not sure whether he acted reasonably or not. That's an acquittal. That's the burden the prosecutor has to show before this is murder. And we just ask that you judge him on the decision and not all this noise around it. It's the split second. Any reasonable officer, This isn't murder. What an impossible decision. Make up your mind. It's not murder. It's not manslaughter. This man did not commit a crime. No one is saying Patrick Loyola deserved to die. That is not what this is about. It's about, in the decision that we've asked Christopher Schurr to make, in that moment where he's supposed to be, whether the prosecutor's shown beyond a reasonable doubt that it was unreasonable. No reasonable officer could have used deadly force in that situation. That's the standard. And their experts don't even agree on what's dangerous. You must acquit him of both charges. Thank you.
Do you have rebuttal?
I do, Your Honor.
Okay. You may go ahead.
Sure. So you have attack prosecution's experts. That's one of the things you gotta take a look at. You gotta take a look at the credibility of witnesses. This is one of the instructions you're getting. Does a witness have any bias, prejudice, or personal interest on how a case is decided? And that includes the experts. That includes everybody here. So you want to compare experts here. Let's compare for science. For science is not an expert entity. For science is an advocacy group for police officers. That's what they're there for. Bond cleaning, and that's their network. That's their whole thing. So you want to compare about why not to believe somebody. Why would you believe an entity that starts out with giving the benefit of the doubt to the officer? That was Von Kleem's testimony. He starts out. So how can you be impartial? How can you be coming from a position of neutrality when you start out, you're going to give the benefit of the doubt to the police officer? Which goes into them finding 98% of the time officers acted appropriately. What other profession is that infallible? What other profession? Name one that they're correct 98% of the time. So that goes into how do you believe they're experts? Yeah, they paraded a bunch of experts out here. And it gives you just an insight of what happened. If you guys remember my question to Mr. Bartel. He said, well, geez, MMA goes 5 minutes, right? MMA goes 5 minutes. Well, that was the dumbest question ever made in the history of cross-examinations because the disdain from the stand just oozed out of his pores. How can you can't compare an officer to an MMA fighter? MMA fighters train for 3 hours a day, so whole years, and blah blah blah. Yet, the next day, when Von Kleem, his partner, his friend, who he presents with all the time, what does Von Kleem do in his report? Compares Patrick to an MMA fighter, because that's what they got to do. They've got to say the opportunity, he has an opportunity because he can spring up like an MMA fighter. That gives you a window in terms of the prism. They translate what happens based on an officer. They like officers, which is perfectly fine. I'm not saying that they shouldn't have advocacy groups for officers, but you judge an officer by one standard, then you judge the victim by another one. That's the opportunity. That was a tactical advantage because why? Because Von Kleem and Lon Bartels do jiu-jitsu and they do grappling. And so ergo, that Patrick has the same opportunity because he can suddenly spring up from a face down or a face on his back position and maybe use the taser. That's what gives him the opportunity. Von Kleem talks about, disproportionate resistance. That's their intent. That's his interpretation. That's what he said. Well, you can determine the intent. Disproportionate resistance by Patrick is why you can think he's going to use deadly force. Von Kleem doesn't want to use that against police officers because they have no idea how can they come up with disproportion. They can't comprehend that. So when you want to talk about bias and prejudice against the experts, you want to criticize ours, take a look at theirs. And then they're comparing apples and oranges. Because our experts are use of force, they say, in terms of taser, what a taser does, what a taser can do. And it's possible for these things to happen, but it's not reasonable to think it is gonna happen. That's the reasonableness test. You can't look at every sort of possibility in the universe of what might happen and then say, oh, it's reasonable that you can do it. I mean, why does anybody take Wegovy? You listen to all the bad things that can happen on any of the drugs that are on TV because they may cause, hair loss, liver problems, and so on and so forth. But they want to use that as justification because all this may happen. It could, the wires could. There is no, talk about distractions. There is no evidence the wires were broken. There is no evidence that anybody was feeling MNI. There's no evidence that wires had any impact. But they got to throw out all these things. You want to talk about another thing? Why isn't GRPD? Why do we ask for GRPD? Does a bank, when somebody embezzles money, investigate their own? No, they call it an independent. They call it an outside organization. How hard is it? And this is not just GRPD, this is for anybody. How do you judge somebody that you trained? I mean, Captain Cyber said, yeah, hey, I was his commander at one point in time. You think they're coming from a position of not bias because you're asking to judge their policies, their procedures, and what this person does? They like him. He's a good guy. How do you come in and say they're impartial? And once again, to give a window on that, what did Captain Cyber say? Because Captain Cyber, when we asked, we said, okay, you've been listed as a defense witness. Okay, what's the policy? If somebody's disarmed with a taser, do you have a policy on that? Nope. No policy. Never heard of it. Yet then he takes a stand in front of you and says, oh yeah, that's deadly force. Well, wait a second. 2 weeks ago when the detective asked you about it, you said, no, there's nothing. But now that, as soon as somebody disarms you of a weapon, that was a weapon. You never said taser specifically, but he was asked specifically about a taser and disarmament. Nope, there's no policy on that. We don't train nothing about that. But yet all of a sudden it changes. That gives you a window of why there's bias. There's a conflict of interest. That's why we have the state police in here talking about it. There's a conflict of interest to try and bring GRPD officers to judge on another GRPD shooting incident. They have every reason, just like anybody else. Just like a bank, you don't ask the people who were responsible for training what went wrong. But even then, and this is what I'm talking about, you can believe all, some, or none. They say Grand Rapids policies are generally accepted police practices. They're one and the same. There's no difference. Both of them say that. So that to create this, he doesn't know what generally police practices are because he wasn't trained on them. It's just a fallacy because it's one and the same according to GRPD. But the other example is Officer Gady. Why couldn't he talk to the officer? I got better things to do. He doesn't want to talk to an officer to give him, I'm not disputing. That's not a dispute. Yeah, when you use deadly force, that's what's trained. You use deadly force, you're going to shoot to kill. They're not going to try and shoot an arm off. They're not going to try and shoot a foot. Why didn't you want to talk to the detective about that? And so he trains. He was part of his recruit class. It's somebody in-house. You can't ask somebody in-house to be completely impartial and unbiased when you ask them to do stuff like that. But when you look at it, when you think about it, when you try and compare in terms of what's going on between these experts, compare the experts, what about Sergeant, I think it was Johnston, the first sergeant on the scene? Let's remember his testimony. Remember what he said? Did he or didn't he not sound like Seth Stoughton? Because he was worried. He said, yeah, we pulled up. I couldn't see inside that car. I didn't know what was going on in that car. I didn't know what the individual that was standing outside the car had. He could have a gun. That's what we teach. We don't know what's going on. I mean, that's the thing. He's got 3 officers at the time, all with handguns drawn, and watch the body cams. How carefully they approach that car because they don't know. That's what they're trained. So it's kind of a contradiction in terms of saying, yep, it's okay for a single officer all by himself to run after and chase and tackle somebody, which flies in the face of their policies that says don't do that you saw. That's a big difference there. How can you chase if they're treating everybody, 3 officers on scene being that careful? Why is 1 officer all by himself? That's okay. That's fine. And so it's not distraction. So what is the purpose of the reasonableness of the officer's actions when you're looking at the totality of the circumstances? If it's just as many times as you snap your hands, there's no totality of circumstances. It's just looking at that moment, period, and what's the purpose of the totality of circumstances, looking how the officer got into that situation. There is no purpose. There is no totality of circumstances. Well, he was, somebody had a taser, you can shoot him. And the interesting thing was, because who did they say? Who did he say? Well, Professor Kroll is the one who said, oh yeah, they're able to use deadly force because he did that study. Professor Kroll isn't a taser expert. He has no idea of police policies. He said, that was his testimony, it was his impression of police policies. Because they can't bond clean, the GRPD officers, nobody can say anything about what the taser policy. There is no. Take a look at all the policies. Take a look at the policy where it says, if you're just starting the taser, you can use it. You can shoot them. Because it's not there. There is no policy. It's based on the totality of the circumstances, based on everything the officer knew at the time. And what the officer knew at the time goes back to when the incident started. The whole thing, not just looking at that one brief second. And why would a reasonable officer, when there's been no aggression, there's been nothing, no punching, no kicking, no hitting, no anything, think he was going to die because somebody had his taser? That's what's not reasonable about all this. And you're right. You're right, manslaughter is going to be brought up. And it was a complete misstatement of the law to say, well, the manslaughter is not an intent to kill. That is not the law. Listen to the instruction. It is an intent to kill. The traditional manslaughter thing is when a spouse shows up and sees their spouse in bed and loses it. That's your typical manslaughter. You lose it and they want to kill him. It's not, well, they got into a fight. A manslaughter instruction is because of emotional excitement. Because of emotional excitement, somebody who's driven to kill somebody. That's what we're talking about here. It is not just, well, there was a fight they didn't mean to. That's a completely different thing. Manslaughter, listen to it. And because of emotional excitement to the point a reasonable person may have acted in impulse. And if anything, that's what their experts are talking about. That's what their experts bring up. Yeah, Professor Lake. Yeah. Heuristics. Heuristics. And I said, heuristics. It's kind of, putting in layman's terms, that means jumping to conclusions. And that's it right there. He doesn't know why he's running, so he jumps to a conclusion. The defendant jumps to a conclusion. Well, there must be something worse here. There must be something worse here. I'm going to jump to the conclusion and think it's a bad thing. That reduces it, so it's justified, excused, it reduces it to a lesser crime. Manslaughter is a lesser crime, so if you think this fight, if you think this battle, you can even characterize it as a battle, because what it is a wrestling match. And that's in the totality of the facts and circumstances. How does somebody want to kill you when they don't do anything else before that? How do they want to kill you? What evidence do they want to kill you? He grabbed my taser, and I'm tired. That's not enough. That is not enough to justify taking another person's life. And watch the video. Yeah, take a look at the video. Yeah, he stands up 3 times, but at the moment he goes to push himself up, the defendant shoves him back down. He shoves him back down. He's got total control over this incident. So to think that he has to kill him at that moment is just wrong. It's not reasonable. Yeah, no reasonable officer would come up with that. And why? No idea why it's so far. Where's the fight? It's not a fight. It's a wrestling match. I thought the other thing that was, interesting about, GRPD puts the fear of God. Puts the fear of God about tasers. Yes. Watch that video. Watch the graduation video. This is the graduation video. So the fear of God, you put that's a serious weapon, but the fear of God in an instrument that you put the soundtrack to Top Gun to in the graduation video, and take a look. Get a closer look. Look at the smiles. Look at the smiles on all their faces. Yeah, they're kind of, somebody's going through it again. It's taking the ride. We're talking about taking the ride. Yeah, it's a serious weapon, but it's not a weapon that's going to cause death or great bodily injury. That's not putting the fear of God into them when you put it to the soundtrack of Top Gun. It's not putting the fear of God into them when you're sitting there smiling at them, smiling at somebody getting tased. It's something you're concerned about, sure. But this whole thing in terms of distractions, it is once again, it's amazing now, because now we're saying don't ignore the defendant's prior statement, ignore it, because it was just a police report. What we heard on the stand, and we couldn't trust his testimony on the stand either. Why? Because, Mr. Dodge asked him, well, you've been 3 years. There's a lot going on in those 3 years. You've been through a lot of trauma. So you can't really believe his testimony by his own, attorneys asking him questions, but then you're also not supposed to pay attention to his written statement, so how do you determine what it is? You gotta take it. That's what the statement's there for. Compare. Compare what the differences are. Take a look what it is. Take a look. Where did the bladed stance come from? Because that's what it says in his written statement. Where's the bladed stance? Because we heard what the bladed stance was by Captain Siren. The bladed, somebody may have a gun. That was a bladed statement. No testimony to that. It was in his written statement. And then I didn't ask him questions. Well, show us the bladed stance. Well, it's a different perspective. You really can't see. So, what we're trying to do is trying to build up the danger of Patrick. Trying to build him up. He had a bladed stance. It was dangerous from the get-go. Well, then if it's dangerous from the get-go, why are you chasing him? And that's part of the totality of the circumstances. You think you may have a weapon, you shouldn't be chasing them. That's what GRPD policy says. It's a bad idea to do that. And you gotta take a look at everything that led up to the decision to fire that shot. And simply getting up is not enough with the taser. He has gotten up 3 prior times and has done nothing. Has done nothing other than try and get away. But you're supposed to jump to the conclusion, using heuristics, jumping to a conclusion that he's gonna kill you. That is not reasonable. It may reduce it, maybe it's manslaughter, but it doesn't excuse it. It doesn't say, yep, go on away. You did nothing wrong here. So when you're looking at everything, yeah, it's a big decision. But a reasonable doubt, you'll hear, I've talked about it before, a reasonable doubt is a fair, honest doubt. But it leaves you firmly convinced. Firmly convinced based on the evidence. Based on the evidence that's presented here. I think when you look at this, when you look at the facts, when you look at the evidence, you should be firmly convinced that there was a homicide here, there was a murder. It was second-degree murder. It was a death caused by the defendant. He intended to kill, and there is no justification for it. Simply having a taser with nothing more does not think, oh, I'm gonna die. We've had all kinds of people up here saying, yeah, we survived. We got tased numerous times. Volume 2 got tased in the head. He's still talking about it. It lasted about 30 seconds. And even in terms of you want to talk about reasonable, yeah, use their expert. Use Professor Kroll. It's never happened. Never happened in the history of policing where an officer's been tased, disarmed his weapon, and killed. And it's his impression that it's because they kill. But the one thing where he said is it's happened 9 times where a person's actually been tased. An officer's actually been tased. But in the other case, the majority of the time, nothing happens. They want to, every possibility to consider, you have to consider what's reasonable. If you have a reasonable doubt, then he committed the crime of homicide. At best, he committed the crime of manslaughter, but he is not justified. He is not excused. Patrick was not a threat. Patrick meant no harm. Patrick wanted to get away because he was drunk or whatever. But the only logical conclusion you have is you find him guilty. Thank you.
Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum it up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way to decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements, arguments, and any commentary are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses, your questions to the witnesses, and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, summary of any evidence, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have and not be influenced by a witness's disability, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There's no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think a witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. You have heard that a lawyer talked to one of the witnesses. There's nothing wrong with this. A lawyer may talk to a witness to find out what the witness knows about the case and what the witness's testimony will be. You have heard from several expert witnesses. Zachary Batchelor has given you his opinion as an expert in the field of video technician and audiovisual analysis. Dr. Stephen Cole has given you his opinion as an expert in the field of forensic pathology. Brian Childs, who has given you his opinion as an expert in the field of taser and body cam by Axon. Seth Stoughton, who has given you his opinion as an expert in the field of use of force and police practices. Nicholas Bloomfield, who has given you his opinion as an expert in the field of police practices and use of force. Captain David Siver, who has given you his opinion as an expert in the field of GRPD training policies and procedures. Captain Chad McCursey, who has given you his opinion as an expert in the field of GRPD training policies and practices regarding taser use of force and duties and functions. Lon Bartel, who has given you his opinion in the field of exercise, sports science, and exertion and exhaustion factors. Dr. Mark Kroll, who has given you his opinion in the field of operations and effects of electrical weapons. Bob McFarland, who has given you his opinion in the field of video analysis. Jason Getty, who has given you his opinion in the field of GRPD firearm training policies and practices. David Blake, who has given you his opinion in the field of human factor psychology and police practices. And Von Kleem, who has given you his opinion in the field of police practices, tactics, policy, and use of force. Experts are allowed to give opinions in court about matters they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts they gave for their opinion and whether those facts are true. You should also think about the expert's qualifications and whether their opinion makes sense when you think about the other evidence in the case. You have heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. Facts can be proven by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proven by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. You have heard evidence that before the trial a witness made a statement that may be inconsistent with their testimony here in court. You may consider an inconsistent statement made before the trial only to help you decide how believable the witness's testimony was when testifying here in court. If the earlier statement was made under oath, then you may also consider the earlier statement as evidence of the truth of whatever the witness said in the earlier statement when determining the facts of this case. The defendant, Christopher Schurr, is charged with the crime of second-degree murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant caused the death of Patrick Lyoya. That is, that Mr. Lyoya died as a result of a gunshot wound from a gun fired by the defendant. Second, the defendant had one of these three states of mind. He intended to kill, or he intended to do great bodily harm to Mr. Lyoya, or he knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of his actions. Third, the killing was not justified, excused, or done under circumstances that reduce it to a lesser crime. The prosecutor must also prove beyond a reasonable doubt the crime occurred on or about April 4th, 2022 in Kent County. You may also consider whether the defendant is guilty of the less serious crime of voluntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant caused the death of Patrick Lyoya, that is, that Mr. Lyoya died as a result of a gunshot wound fired from a gun by the defendant. Second, the defendant had one of these three states of mind. He intended to kill, or he intended to do great bodily harm to Mr. Lyoya, or he knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of his actions. Third, the defendant caused the death without lawful excuse or justification. The crime of murder may be reduced to voluntary manslaughter if the defendant acted out of passion or anger brought about by adequate cause and before the defendant had reasonable time to calm down. For manslaughter, the following two things must be present. First, when the defendant acted, his thinking must be disturbed by emotional excitement to the point that a reasonable person might have acted on impulse without thinking twice from passion instead of judgment. This emotional excitement must have been the result of something that would cause a reasonable person to act rashly or on impulse. The law does not say what things are enough to do this. That is for you to decide. Second, the killing itself must result from this emotional excitement. The defendant must have acted before a reasonable time had passed to calm down and to return to reason. The law does not say how much time is needed. That is for you to decide. The test is whether a reasonable time passed under the circumstances of this case. The defendant's intent may be proven by what he said, what he did, how he did it, or by any other facts and circumstances and evidence. You must think about all the evidence in deciding what the defendant's state of mind was at the time of the alleged killing. The defendant's state of mind may be inferred from the kind of weapon used, the type of wounds inflicted, the acts and words of the defendant, and any other circumstances surrounding the alleged killing. You may infer the defendant intended to kill if he used a dangerous weapon in a way that was likely to cause death. Likewise, you may infer the defendant intended the usual results that follow from the use of a dangerous weapon. A gun is a dangerous weapon. A dangerous weapon is any instrument that is used in a way that is likely to cause serious physical injury or death. You may return a verdict of guilty of the alleged crime, guilty of serious crime, or not guilty. The defendant claims he acted in lawful self-defense. A person has the right to use force or even take a life to defend himself under certain circumstances. If a person acts in lawful self-defense, that person's actions are justified and he is not guilty. You should consider all the evidence and use the following rules to decide whether the defendant acted in lawful self-defense. Remember to judge the defendant's conduct according to how the circumstances appeared to him at the time he acted. At the time he acted, the defendant must have honestly and reasonably believed that he was in danger of being killed or seriously injured. If the defendant's belief was honest and reasonable, he could act immediately to defend himself, even if it turned out later he was wrong about how much danger he was in. In deciding if the defendant's belief was honest and reasonable, you should consider all the circumstances as they appeared to the defendant at the time. The relevant consideration is not what the defendant should have known or done, but rather what a reasonable officer with the knowledge and in the situation of the arresting officer could have believed at the moment the officer made the decision to use deadly force. Reasonable is that which an ordinary, prudent, and intelligent person with the knowledge and in the situation of the officer would have deemed necessary under the circumstances. A person may not kill or seriously injure another person just to protect himself against what seems like a threat of only minor injury. The defendant must have been afraid of death or serious physical injury. When you decide if the defendant was afraid of one or more of these, you should consider all the circumstances, the condition of the people involved, including their relative strength, whether the other person was armed with a dangerous weapon or had some other means of injuring the defendant, and the nature of the other person's threat. At the time he acted, the defendant must have honestly and reasonably believed that what he did was immediately necessary to prevent death or great bodily harm to himself or others. A police officer in defense of himself or others may use that force which is reasonable under the circumstances. Unlike the private citizen, a police officer, by the necessity of his duties, is not required to retreat before a display of force by his adversary. If an officer is authorized to arrest or detain someone and the person resists, the officer is entitled to use a reasonable amount of force to overcome that resistance. Like the private citizen, a police officer must reasonably believe himself to be in great danger and that his response was necessary to save himself from that danger. The defendant does not have to prove that he acted in self-defense. Instead, the prosecutor must prove beyond a reasonable doubt the defendant did not act in self-defense. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. When you go to the jury room to deliberate, you may now take your notes and these full instructions. If you want to look at any or all of the exhibits that have been admitted, just ask for them. When you go to the jury room, you will be provided with written copies of these final jury instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a business-like way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own and you must vote honestly and in good conscience. If you have any questions about the jury instructions before you begin deliberations or questions about the instructions that arise during deliberations, you may submit them in writing to my clerk. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to my clerk. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. That concludes our final instructions. We'll now pick 2 individuals that will be alternate jurors. So what that means is for today, you are excused. However, you still have the same restrictions as before. I'm going to ask those 2 individuals to leave your notes in here on the chair, and we'll make sure they're destroyed in the event that you're not needed as an alternate juror. But it's still for you, again, to maintain the restrictions as before, not access any news reports or discuss the case with anyone, because if we need to call you back as a juror, obviously if you've been out posting on Facebook about how you were a juror and all that, then you wouldn't be much use as a juror in the case. So those 2 individuals will still be, again, under the same restrictions, and then we will follow up and let you know when a verdict has been reached so that you know that you are discharged, whoever those 2 people are. And I'd also like to take this time to thank those 2 individuals for your time and attention for this case.
Seat number
Wait,
2,
so
120.
just because we're on, don't say the person's name, just say the seat. Seat number.
Seat number 2.
Yes. It's seat number 2?
Correct.
Okay. And
Seat number 1.
okay. So 1 and 2 would be you in the first 2 seats from the corner. And again, thank you very much for your time and attention, and we will let you know when a verdict has been reached so that you know that you're discharged. But if you just hang out for
Good
just
afternoon.
another
You have just seen
moment,
closing arguments in the case of former Grand Rapids police officer Christopher Schurr. Schurr is charged with second-degree murder in the killing of Patrick Lyoya. Now, at this point, the jury has been instructed to deliberate amongst themselves and come back with a verdict which will decide Christopher Schurr's fate. Let's take a moment to break down what Schurr is charged with. Second-degree murder is defined as a death caused by an act of the defendant, that's Schurr in this case, with malice. Another element of second-degree murder is that the act causing the death is, quote, without justification or excuse, unquote. That element is part of what will be argued and was argued in this trial, as the State of Michigan Court of Appeals believed there was enough evidence for a jury to determine if Schurr was justified to kill Lyoya due to self-defense. This is a felony with up to life in prison as a punishment. Today, a lesser charge has also been offered to the jury, second-degree manslaughter. That fits into similar guidelines, but if convicted, would show that Schurr did not intend to kill Patrick, but rather did intend to cause great bodily harm, and the killing would have resulted from reckless and careless actions. Again, we are just now wrapping up court today. We were able to hear both closing arguments and the rebuttal from Prosecutor Becker. We first started with closing arguments from Prosecutor Becker, who essentially went through his argument, saying that this killing was not justified, hitting on points about whether or not what the juror saw today. He says that it's not a simple case. It's not a simple case of a bad guy versus a good guy. There are elements that are simple to this case, but it's not as simple as a bad guy versus a good guy. He talked about things like bringing up the taser, saying that someone simply having a taser, part of him, does not lead to someone being killed the way that Patrick Lyoya did. He also talked about deadly force, saying that someone having a taser and being inflicted with pain should not cause death for somebody. Let's bring in Riley Mack, and Callie Lichter, both inside the courthouse all day long. Ladies, we just heard the end of the closing arguments and the rebuttal. Kind of walk us through, what did we hear exactly?
Before we started, Lauren, I just want to say, if you hear some noise in the background, there are some demonstrators across the street who have been here all week in support of both sides in this trial. I just wanted to say that if you're hearing anything right now.
Yeah, absolutely. And we started this morning at about 9:20 a.m. The defense rested after about 12 witnesses. The prosecution had 8 witnesses at the start of this trial. And then we heard, closing arguments, and the prosecution really started by introducing Patrick Lyoya as a man, as a human being. He pointed out his family, who's in the audience of the courtroom. He said he admits, Patrick was not a saint, he says, but none of the crimes that he committed that day, not listening to the officer, resisting arrest, drunk driving, he says none of these deserved a death sentence. He said that he had to prove three things in this trial: that Schurr killed Lyoya, that he intended to, and that the killing was not justified. He said the first two, were proven right away through that video. The third one, he had to prove to the court, and he said that he did that through his expert witnesses, through all of the evidence that he's shown in this trial. He also said that, Schurr went against GRPD policy. When he chased after Lyoya at the start of that traffic stop. He says that Schurr didn't know the risks. He didn't know if there were weapons inside that car. There was another passenger in the car. He went against policy by chasing after him and putting himself at risk for that. He also said there's no GRPD policy on tasers, that, we can't say that he followed what a reasonable GRPD officer would do because we don't know what that is. There's no GRPD policy on when to escalate from a taser to deadly force. He also said that Schurr made mistakes on that day. He said that he was chasing after Lyoya when he shouldn't have been, and that he was outnumbered. But again, these mistakes that he made did not justify him shooting someone. We also learned that in Schurr's reports to the Michigan State Police after, the investigation took place, Schurr wrote that, Lyoya began to walk away, that he began to turn away, that he was moving his arms and legs in a way to get away. And, the Kent County prosecutor, Chris Becker, ultimately said was Loyola just trying to get away? Was he trying to take that taser so that Schurr didn't use the taser on him? He ultimately argued that these are not actions that would justify someone being shot. This sounds like a person who was trying to get away from police. And he really ended in that argument by saying this is not what a reasonable officer would do. What do you think, Callie?
I mean, this whole entire case, Lauren, hinges on hindsight. You have both sides saying that these witnesses who the respective sides called in aren't commenting on hindsight. They are saying that the decision by the jury needs to be made in that moment. And you have a difference between the prosecution and the defense on, what was known at the time and what a reasonable officer, or in this case, Schurr, would have done. And then you have the defense saying that if any officer was in Schurr's shoes, and they even brought up, they called in a couple people on the force currently at GRPD, other former officers, and their point was like, you have all these former officers, current officers, captains who are coming in saying they would have made the same choices that day. They're not speaking in hindsight, they're speaking as almost this reasonable officer character, but you have the prosecution then, rebutting that and saying no reasonable officer would have done that if you take in the totality of the circumstances. That's another word that we've been hearing throughout the trial. The totality of the circumstances. What is everything that happened in that incident only? Looking at that incident, what should Schurr have known? What did Schurr know? And then what did he do based on his knowledge? And so again, the closing arguments that we saw couple of 30 minutes now, an hour. It was the last time that both the prosecution and the defense can really get their point across to the jury on what they believe went down that day.
Ladies, just before closing arguments, we heard that the second charge, manslaughter, was actually brought into what jurors can now decide on. Can you talk about that conversation of the defense not wanting manslaughter to be in, but then also that kind of back and forth between the defense's closing argument and the prosecution's rebuttal talking about manslaughter in this case?
Go ahead, please.
When it comes to, a voluntary manslaughter charge, that is the lesser charge that's kind of been referenced throughout this whole entire case. It's beyond a reasonable doubt or lesser charge. The defense, through a motion, which was, I believe, talked about even before the trial started, they didn't want, this to be an option. They objected to having this as an option or disagreed. Can't think of the word off the top of my head right now. But the defense didn't want this to be an option, and it comes down to they hope the jury finds their client, in this case Christopher Schurr, innocent. So they don't want, another option on the table. That's another thing that they have to, or I guess not defend against again. Schurr is innocent until proven guilty. The defense doesn't have to do anything. It's on the burden of the prosecution, to prove this case. But, they don't want that other option when it comes to, they're here for the second-degree murder charge. They're kind of talking about, not having that as an option, but the judge disagreed. She said, she disagreed with the motion of the objection, and she's going to allow that to be an option that they could find, Schurr guilty on if it comes to it.
And the defense brought up in their closing arguments, they said that the prosecution introduced this charge because they believe that their case is weak. That's what the defense was saying in their closing arguments. And they both had different definitions of when this charge comes about. Really, it's just the excitement of the moment can create that deadly force situation. And that's certainly something that they've, the totality of the circumstances they've been speaking on, those sort of circumstances throughout the trial.
And ladies, I know that you had to rush down outside of the courthouse to talk to us. So if you were able to hear the judge start to go through the instructions of what the jurors have to decide on, can you talk about the evidence that they have to listen to it that might not include what they actually heard? It has to be actually very concrete things they have to decide on.
Yeah, I mean, she spoke on jury questions. I know that was a big piece in the beginning of the trial that she said, the jury is allowed to ask questions. That's not always the case in the courtroom. She said that, the jury questions themselves are not evidence, just how the person answered those questions, I think she said. The specific witnesses, it was a very specific instructions on what can be admitted and what isn't.
And you know, they've been asked since the very beginning, and it was kind of reiterated in these instructions, is that they can only listen to the evidence that's been used in this case, the witnesses who have appeared on the stand in the case. There's been so many things outside of this case that have been, you know, brought to light over the past 3 years, whether that's through news reporting, like reporters here at stations, newspapers, or just, you know, things that have been released by investigators, by detectives. But they're being asked, you know, to only consider what is being said in this case, in this moment. And again, it goes back to the totality of the circumstances. Yeah. When everything is considered, what the jury believes should be considered, because they were told that, you know, there are some times where you can choose not to believe a witness, or not at least, you know, think one witness is as credible as the others. So when it comes down to their opinion, piecing together what they believe to be the case and their final decision, they can only think about what's been said in that courtroom in front of them.
And ladies, there are people who are demonstrating behind you. It looks like it's a BLM flag flying behind you. Can you just maybe talk about what you all are seeing out there? Is there a large presence of people in support of both sides? What are you seeing right now?
Yeah, so there's definitely been a steady presence all week of people on both sides. I know that when we've arrived to the courthouse every single morning, you know, these groups kind of ebb and flow as the day goes on. But, you know, you have, I'm going to check behind me real quick and see who's out here. Over the past, I guess now it's been a week, because the trial started last Monday. You've had people out here with Black Lives Matter flags, posters, justice for Leoya, and you've also had people on the other side, you know, waving thin blue line flags while they're out here, saying justice for Schurr. And there hasn't been a huge clash. You know, there's been some times where the groups have kind of met head to head on the sidewalk, but there's also a large law enforcement presence that's been here throughout the whole entire trial, even during jury selection when Riley and I were here for that. You know, making sure that everything is calm, staying under control. Nothing has, you know, necessarily gotten out of hand. It's people who are exercising their First Amendment right on both sides out here on the sidewalk in front of the courthouse.
Yeah.
And ladies, now that we've heard both opening arguments, closing arguments, you guys were both there for both arguments. Can you maybe talk about the comparison of how this trial started to now, how it's ending? Did the closing arguments kind of really connect to the opening arguments, or I guess any differences that you saw?
When it comes to the prosecution's closing argument, you know, it kind of started out the same way, you know, like one shot to the head. And it was really Becker and the prosecution, you know, through him, saying that this, in their belief, was unjustified. What started as a traffic stop over a license plate, over, you know, driving that kind of was out of the norm, you know, someone ended up dead. And so they were trying to reiterate to the jury that this was unjustified. And while there could be some justifiable actions during the incident, you know, there were things that were unjustified. And that's what they're really hinging on. And, you know, Becker went through his points, kind of bringing back, you know, witness testimony, reminding the jurors what they've heard over the past week, but also bringing back the points that he was trying to prove and the prosecution was trying to prove through this whole entire trial, you know, how this was unreasonable and unjustified. And he said that's really at the core of it, and kind of saying, you know, through Schurr's own statement, they brought up the Michigan State Police statement that was given around, I believe, 11 days after this incident happened. You know, what he said then versus what he was saying on the stand just last week. And kind of pointing out the differences in that, saying, you know, how can he say one thing and then say the other? And then how does that make that justified based on what was in this report and the responses to the questions that were asked by the Michigan State Police? So again, it really went back on this. It was unjustifiable for the situation to escalate from point A to point B, in their opinion, and was really trying to hit that home for the jury.
And I feel like on the defense's side, you know, they similarly kind of brought it full circle. At the beginning, Michaela Hamilton from the defense team spoke on, you know, more of a narrative perspective of Schurr's day that April 4th morning, how he woke up for work at 4 a.m. and he kissed his wife and his dog goodbye and he left for work to go protect the people of Grand Rapids. And they spoke on, you know, his job as a policeman is to arrest people who are breaking the law, which they said Leoya did. They say he was doing his duty as a police officer to arrest him that day, to chase after him. And they really spoke on, more of the narrative side of that from Schurr's perspective, which we got a lot of during his testimony. Really that perspective of a police officer doing his job has been the kind of the narrative that they're trying to sell in the opening and closing statements.
And again, ladies, we know that now that there's a second-degree murder charge and a manslaughter charge that the jury does have to deliberate. Can you just once again, for people who maybe just tuned in, break down what the jury has to decide on for both of these charges for Schurr to be convicted of?
So you're going to have 12 jurors. There are 2 alternates. So all 14 were staying in the jury box throughout the duration of the trial, but then there are 2 jury members who are randomly selected to be alternates. They're not going to vote. So that's where you get the 12-person jury and the 2 alternates. And so, they're going to have to decide, reasonableness beyond, doubt, which is kind of what you're going with the second-degree murder charge. And then you also have the manslaughter charge. Was it lesser? Was there a lesser version of this shooting? That's basically what they're saying. If you can't prove one thing, can there at least be proof for another thing? I don't have the definition of voluntary manslaughter in front of me right now, but it's kind of that when they're speaking about that lesser charge, they're speaking of that manslaughter charge, which has now been brought into play.
And ladies, for people who maybe don't know, every day that we've seen something happen, we've always seen a lunch break happen at this hour. Can you just confirm to us, the jury is deliberating right now, correct? Or what is happening right now?
That's correct, yes. We kind of went through our lunch hour a little bit when we were closing those arguments. We were doing the rebuttal, but now the judge has broken it off. We are doing jury deliberations now, so it truthfully could be any moment when we come back with a decision.
Well, ladies, I appreciate you jumping in to kind of break down what we just heard. I know that you guys are itching to get back into that courthouse. Again, thank you so much for joining us. We now want to bring in some experts we've been talking to this whole entire trial. Joining us right now is Tanya Cross-Phelan, Andrew Rodenhouse. Tanya, Andrew, thank you so much for joining us. I just want to start right off the bat. We just heard closing arguments for both sides and the rebuttal. Kind of talk about what's going through your head. What really stuck out with these closing arguments? Andrew, I'll start with you.
Well, first of all, I thought both parties did a good job presenting what their case was and making closing argument about what they thought they had established. And that's the point of a closing argument. As part of the jury instructions, they're instructed that what the lawyers argue is not evidence and that they're only to consider the evidence as it was given to them through the witnesses and by the court. But I thought both parties did a good job summarizing what they believe the evidence established. I thought Mr. Bergola did a nice job of explaining how the lesser included, they still have to prove that it was without justification, even on the lesser included of the manslaughter. I know the question is going to come that what is manslaughter? Well, I'm going to pass to my professor who taught exactly that in law school, because there's about 15 different varieties of manslaughter, and I'm thinking they're just getting a simple voluntary manslaughter instruction.
Yeah, Tana, if you could just jump in and kind of explain to us what voluntary manslaughter is. We too tried to look up the definition of it and multiple came up. So we just want to, if at least for this case, kind of help people understand what this second charge is.
Sure, and I want to just go to your first question first, and I agree that the lawyers were very consistent in their closing arguments with the theory of their case. We've talked at the beginning of this trial about how opening statements, the lawyers can't argue. They simply can say what they think the evidence is going to be throughout the trial. But when you hit the closing argument, now the lawyers really get to come in and they get to say, this piece of evidence means this because. You hear a lot of because statements, and that's what we mean by argument. And the argument was consistent with what we saw them develop in opening statement and through the questioning of all their witnesses throughout the case. So in that respect, both sides did a really nice job with their closing arguments. With respect to voluntary manslaughter, it is a less serious form of homicide. Now, as I understand it, the defense objected to the voluntary manslaughter instruction being given to the jury. And the reason I anticipate the defense objected is because now there's sort of a middle ground for the jury to hang their hat on, right? We call it a compromise verdict. And that could, if jurors compromise, if some are saying, gee, I think it's second-degree murder, and some jurors during deliberation are saying, hey, I think he's not guilty because it was self-defense, they can maybe bridge that gap and all settle on manslaughter so that they don't result in a hung jury, meaning the jury could reach a verdict. So I anticipate that's why the defense didn't want it, and I anticipate that's exactly why Prosecutor Becker wanted that lesser included instruction. So manslaughter, as I said, is a less serious form of homicide, and homicide simply means an unlawful killing of one human being by another. So as we've talked all along, second-degree murder, just a reminder for the audience, the prosecutor had to prove that Mr. Schurr caused Mr. Loyola's death, that he did so with malice, intent to kill, and that it was not justified, meaning it was not lawful self-defense in this particular case. Now, manslaughter, if they just gave the simple manslaughter instruction, that means it's a less serious form of homicide. But there's also this idea of manslaughter that it can be a result of heat of passion, right? That there was some kind of provocation that caused Mr. Schurr to act in that passion. Instead of cold-blooded murder, we're talking about passion, and that he responded to that passion before he had time to cool off. And that's typically what we mean by voluntary manslaughter. That's one of the most common forms of voluntary manslaughter.
Can you maybe talk about how that can complicate things, or does it? I mean, this whole trial, we have been watching for a second-degree murder charge. Now this new charge comes in. To me, I'm now no expert, just a normal person who would think, okay, now I have to think about this case completely different. And also, the defense and prosecution has been arguing on a second-degree murder charge. To me, it kind of almost seems like the defense didn't get a chance. I mean, they did in their closing, but a chance to really kind of argue that as well. Kind of talk about that.
Sure. And, you know, as was already pointed out, even with a voluntary manslaughter charge, the prosecutor still has the burden to prove that it wasn't justified. So I want to make sure that that's clear to the audience. But you're exactly right that it could confuse the jurors because they didn't hear anything about manslaughter at the beginning of this case. Remember, judges give instructions at the beginning of the case as well, and they read the charges to the jury. They tell the jury what the defendant is charged with, and that was never mentioned. So it can raise confusion with the jurors. And so that's where this idea of a compromise verdict comes in, right? Where if you have some jurors who think, hey, he's guilty of second-degree murder, and others thinking, no, he's not guilty because he acted in lawful self-defense and therefore the killing was justified, they can kind of come to the middle ground and vote on that voluntary manslaughter charge. Now, when the jury goes back into the deliberation room, they will be given a verdict form. And if Judge Mims is consistent with how most judges in Kent County operate, the first thing that will be on that jury verdict is that we, the jury, find the defendant guilty of, and they list the most serious charge, second-degree murder, and they'll be allowed to say guilty or not guilty. Then they'll see the voluntary manslaughter charge and can vote guilty or not guilty. And then there will be the not guilty line if they completely find him not guilty and acquit him. So now there's this middle charge, right, that's going to rest between second-degree murder and not guilty when they go into that jury room. But before they can reach a final verdict, they're supposed to deliberate on all charges presented on the verdict form.
Andrew, I'd love to hear your take on this. You actually talked to us earlier and said that you thought that this possibly could happen. We now have seen it happen. I guess, what is your reaction to now this being in play for this trial?
Well, I exactly agree. The problem is that when you get into that jury room, and I've had this on multiple times, where if you've got a compromise place where people can land, they will often land there. It's called, in politics, we call it log rolling. So you might have jurors that are like completely not guilty on everything, and jurors that are completely guilty of second degree, and they want to try to resolve the case, and oftentimes you see it play out on a Friday afternoon about 4 o'clock, and all of a sudden they land on the guilty on the lesser included, and it just feels like it's, you know, I don't see how either side is happy with that. But I think Mr. Borgola pointed it out. Like, look, this even if you're considering it, it's still a complete defense. And I think Mr. Becker was asking for it because he's like, well, even if I didn't prove that he intended to kill him, that he intended to cause him great bodily harm, and he wasn't justified in causing him great bodily harm. This is the type of thing, again, like with the experts, that the Court of Appeals will have an issue with this if they think it was given in error or over the party's objection. And so these are the types of things that, if there is a conviction, could put the conviction in jeopardy at the Court of Appeals. But let's let the jury play this out. I think it's important for the jury to deliberate. They've got the case now. Finally, we got through the whole trial. I'm pretty sure everyone is exhausted, and now they want to have the jury do what the juries do, which is deliberate. Now, the first thing they have to do, and they might not want to start right away. They might actually decide they want to go get lunch, and so that's pretty typical when a case is given to the jury just around noontime or around 12:30. They will oftentimes decide that they want to go to lunch first and then come back to deliberate. And so it could be fast, or I've had jury deliberations that have taken up to a week. So who knows? Nobody knows. And it's just one of those things that they teach us in law school patience by not giving us our grades right away. And so we have to just wait patiently.
And you brought up something that I was going to ask you about, which was the appeal. If there is an appeal after, and before, from what our knowledge was, is that appeal will be focused on that second-degree murder charge. If for whatever reason they decide to convict Schurr on the manslaughter charge, does the whole entire trial that hasn't been focused on that charge, does it go out the window? I guess, does that complicate the appeal process? Because to me, it just seems like it just scatterbrains it.
It could, and that it determines on how the jury deliberations return. If they find him not guilty of the second degree and they find him guilty of the lesser included of manslaughter, and the case gets reversed, well, he's already got jeopardy attached to the murder too, and so they would have to retry him solely on the manslaughter, and so potentially if the jury comes back as the second degree and then it's reversed, then he would only, rephrase that. If the jury acquits him of the second degree and then moves on to the manslaughter and convicts him of the manslaughter, if it's reversed, then it would come back and the trial would be on just the manslaughter.
So potentially we could have a whole nother trial if that happens.
Potentially. It happens often enough where well, I mean, I think Harvey Weinstein is having his trial this week too. So it happens across the country where large, high-profile cases are reversed and you just have to try them again.
Tanya, I want to bring you in to kind of talk about some of the things that stuck out to me when the judge was talking about the instructions for the jury. She honed in on deciding the trial based on the facts, and she talked about how saying what lawyers will say are not facts, or the questions that they might have asked and those answers are not facts. Can you kind of explain the importance of that? Because I think when we hear a trial like this, we're like, oh my gosh, so much was said. They had to focus on those words, but it's actually very specific on what the jury is actually looking at.
Yes, and it's a very common instruction. It's a standard instruction, as a matter of fact, that what the lawyers say throughout the case in their opening statements and closing arguments is not evidence. And a few days ago, I was talking about the idea that lawyers cannot be advocates and witnesses in the same case. So evidence in a trial comes in through physical documents and exhibits and what the witnesses testify to. And the jurors are limited to considering only those things. Sometimes there'll be stipulated facts, but they're limited to those things that have been received by the court as evidence in the case. So it's very common in both the preliminary instructions before a trial starts and in the final instructions just before deliberations begin for the judge to remind jurors that, look, what the lawyers say is not evidence. Our opening statements and closing arguments are tools that we use as advocates to sort of guide the jurors where we want them to go and how we want them to interpret and find the facts. But at the end of the day, it's not evidence. And it's also important in this particular case because it took 3 years to get to trial, right? And in that time, there has been a lot of outside discussion about this case, including from the civil lawyers who have been talking quite a bit to the media over the course of 3 years. So the judge wants to make sure that the jurors are not, that they have blinders on, if you will, and that they're not considering any of the stuff that's going on outside of the courtroom when they go back into that jury room and deliberate.
And you bring up the civil case, which is something that we have talked to Ven Johnson about. He's representing the family in that civil case. For people who maybe will get confused, can you just help us understand that a criminal trial and a civil trial aren't connected and the outcomes can be very different?
It's exactly right. There's a whole, crimes are charged as wrongs against the community, right? We have a code of conduct as members of a community that we agree to live by. Those are the criminal laws. They tell us what we can do and what we can't do. And so when a person is accused of committing a crime, that's why they're prosecuted by a government official. When we look at the civil cases, those are private cases between one party and another, where they're saying you wronged me, or in this case, you wronged my deceased family member and committed a private harm against him. And so that will be a tortious type of claim. And if there is a finding of responsibility in the civil case, then monetary damages will be awarded. When someone is found guilty of a crime, there's no money paid unless it's restitution, but the consequence of finding of guilt is the possibility of incarceration. So two very different issues are being litigated in a criminal case versus a civil case.
And Angie, I just want to jump back to you really quickly. I know that you just said this, but just so we're all clarified on this situation, if Schurr is convicted of manslaughter and the appeal finds that he wasn't, then there is the retrial. It has to be first convicted, then the appeal has to go through, and then there's a retrial. Am I understanding that correctly?
Yeah, and let me just explain how it starts with the jury verdict form. And so on the jury verdict form, they'll be instructed to make a determination on murder in the second degree first. And so the first thing they need to do is deliberate whether or not the prosecution proved beyond a reasonable doubt that Mr. Schurr was not justified and that he did in fact intentionally kill Patrick. And if they did that, then they will find him guilty of second degree murder, and then they won't deliberate whether or not there was the lesser included, because then they will be done. But if they find that he's not guilty on the second degree, and then they move on to deliberate on the lesser included of manslaughter, and if they do find guilt on manslaughter, because he was already acquitted of the second degree murder, jeopardy attaches. And in the United States and Michigan, you cannot be tried twice for the same crime if you're acquitted. And so if it's reversed on appeal, he will already have been acquitted of the second degree murder, and any retrial, if there is a retrial, and that's a long ways away, and that's a lot of ifs, but if you do end up in that spot, then the retrial would be on the lesser included of manslaughter.
And we're going to be wrapping up our coverage pretty soon, but I just want to get both of you all's final thoughts on this trial and where we are at this point in the trial. I'll start with you, Andrew.
Well, I'm happy that this trial has been gotten to the jury. I think it's important for the community to understand that this is a whole process, that if Mr. Schurr is acquitted, that he was afforded due process, that the community was able to see, hear all the evidence, and that it was fair. And if he's convicted of something, I want everyone to understand the same, that this is a process and that there is more things down the road, and he has more process rights down the road. And so the big takeaway is that this was a big case for the community, and it was nice for me personally as a lawyer to see how the judicial process play out in public, where people can see like what it actually is like in the courtroom.
And Tanya, I'd love to hear from you as well.
I totally agree with everything that Andrew just said. And one thing I think also is important for the viewers to consider as now the deliberations play out is there's no way to know how long the jurors will deliberate. Jurors might come back really quickly, or they might take several days to go through this. And if at some point during the deliberations, the jurors can't reach a consensus, they may actually come out to the judge and say, hey, we're split, we can't agree. And judges normally, the first time a jury does that, in any case, the judge usually will say, hey, we get that this is difficult, but you heard the testimony, you saw the evidence, it's your responsibility to go back and continue deliberating with respect and due diligence and try to reach a verdict. So that could possibly happen. I mean, there's a whole spectrum here of quick verdict, long verdict, or the jurors struggling throughout the process. And there are no tea leaves to be read there, right? There are absolutely no tea leaves to be read there. Any of those outcomes is normal because every criminal case is different.
And just for those who might not know, is it a majority that has to come to an agreement? Is it unanimous? What's in this case?
In criminal cases, the verdict must be unanimous.
All right. Well, thank you, Tanya and Andrew, for joining us. I would say that this is over, but clearly it's not. We still have deliberations still happening right now, so we will be checking in with you once we get that verdict. We're now going to conclude our stream at this time. We're doing this because, as you know, jury deliberations are not on a set time and can even take days to come back with a verdict. We will be informed by the court as soon as possible when that verdict is reached, and we'll be live on 13 Plus as soon as the verdict is reached. In the meantime, you can watch days of coverage on demand on 13 Plus and read more online at 13onyourside.com and catch up on our live blog, which breaks down all the testimony across 6 days. We'll see you right back here on 13 Plus when that verdict is reached.